Right, it's time to resume the inquiry for the afternoon session. There's just one thing I want to mention concerning the session early today with evidence from Mr. Woods in relation to flood risk. I didn't ask if the parish councils wanted to put any questions to Mr. Woods on the basis that there wasn't any specific mention of that. The parish councils, as I understand it, are cooperating and in large part presenting a joint case. And in the joint statement, whilst it covered a number of areas, flood risk wasn't one that was specifically mentioned. But on double checking over the lunch adjournment, there is mention in Councillor Britton's statement, and he is part of the joint parish council group, of reference to concern about drainage, and on a precautionary basis, I thought I should just check whether, given that reference, the parish councils did want to put any questions to Mr. Woods. But I'm not sure whether any of their representatives are back from the lunch adjournment yet.
Inspector, I'm the only parish council representative here at the moment from Bramley.
Is it Councillor Stern? Yes.
I don't have the same familiarity with this area as my fellow councillors,
yes,
who are from the parishes nearer
yes.
to the site. And I'm not sure whether the questions relating to drainage, I mean, there's two. First of all, that area.
Well, I don't want to go into it. I just want to check whether, because of the drainage stroke flood risk, and the parish council did want to put any questions to Mr. Woods.
I wouldn't know how to phrase the questions, to be honest, but my understanding is there are two issues. One is the surface water drainage, which has been substantially.
Well, if your colleagues are coming back later on, perhaps I'll check that with them then.
Okay. And the second one is, I don't know whether it's been mentioned, is the sewage.
Yeah.
But I don't know whether that's been mentioned to you.
I've not seen any specific reference, but I'll check that later on. Okay. Is there anything any of the parties need to raise at this stage?
Not from us, Inspector.
In that case, I think Ms. Cottle, you were going first, aren't you, on this?
Yes, sir. So, good afternoon, Mr. Simmett. What I'd like to do is to begin by taking you to page 76 of the appendices to your proof, and it's paragraph 99 of the circular of 06/2005. '99.
Okay.
And your point, or the planning authority's point, and it's the reason for refusal, is that because there'd been a record of a woodland white butterfly in adjacent premises, it's not unreasonable to require a survey to be done, and insufficient information had been provided. And so therefore that was a reason for refusing planning permission. And my question to you is that the requirement for a prior survey isn't written in statute, and it's not written in the planning policy, and in the circular there are exceptions to it. So it's not a mandatory requirement.
It's not just the wood riot I'm concerned about, but the other protected species apply here as well, such as reptiles and bats, for example, and the great-crested newts. And the circular is government guidance on what material considerations are. And we know from the appeal decisions looked at in my evidence that inspectors do take that seriously.
Well, of course, in the landfill case that you refer to, ex parte Hendy, I think it was decided in 2001. According to the facts of that case, where you've got landfill going on, there were quite large scale concerns, and the matter hadn't been addressed, and so therefore the permission was overturned for that reason. I can understand that. But my question to you is that it's not a statutory, and it's not a policy, and it's not a circular requirement that there has to be a survey.
I think that the status of the government guidance in that way is perhaps something maybe better presented as planning evidence in how much weight that guidance has. But you're
Well, I'll leave it to the planning evidence, and I think it's also fair to you to leave the construction of the policy to planning evidence as well. Because what I put to you is that in this case, the question is, does the inspector have sufficient information to grant planning permission subject to the conditions that we put forward? That's the essential question.
yes, that's the question, and my answer is clearly that there's a big deficiency in the information available.
If we could now turn, please, to the inquiry documents which come from the third parties. And I did have the reference for the thatched farm house condition, which is one of the inquiry documents, sir.
Is this one that came in last time?
It came in on the first day. And I'll just find it for you. Thank you very much.
It's the last of the IDs before we broke up.
That's right. And if I could take you, please, to the section of the report recommending permission on biodiversity and compliance, and it's on my page, electronic page 18 of 33 of this document. And there's a consideration there of ecology that refers to wildlife trust and the habitat survey, etc. Okay, so this would be in the middle of the report that's attached to the grant of planning permission. The heading comes after impact on trees, it comes after flood risk, crime and disorder, and then climate change, and then biodiversity and compliance. Have you seen this document before?
Yes, I think so, yeah.
So here's a site where there is reference to a woodland white butterfly. Here's a site with a pond assessed with having greater crested newts in it. My client, Mr. Simon Doherty, is facing an appeal where you have said, if there's a whiteland wood butterfly habitat there, and he's the same distance from that pond with the greater crested newt. So how do I explain to my clients that the adjacent land with the newts and with the butterfly has got the permission to go ahead with the 3 barns, as I understand, let me get it correctly. It's erection of 3 light industrial units and associated works. How do I explain to my client that whereas he's got the newts migrating from there, whereas he might have a whiteland woodland butterfly migrating from there, the place where they're coming from gets planning permission on the basis of surveys having been done and on the local planning authority being satisfied with conditions that those ecological interests can be safeguarded. Why is he here in this appeal? Why couldn't those concerns be dealt with in the same way? Isn't it unfair that Thatched House Farm gets planning permission and it's conditioned and his appeal can't be? How do I explain that to my client?
I wasn't involved in that case at all. And on the second page of that document, you can see a condition was imposed that a reptile presence survey was required to be undertaken to assess whether reptiles are using suitable areas, but it doesn't include the wood white or great-crested newts. So I believe the council in that case made a bad mistake, and the decision wasn't in accordance with planning policy and case law.
Well, it would suggest that the white woodland butterfly wasn't there.
It suggests perhaps that it hadn't been brought to the council's attention and they hadn't thought about it themselves. So I think it was a bad permission.
They knew that there was a habitat created for it to encourage it to come along, but it hadn't arrived.
That was January 2023. I can't remember the date of the report.
2023, that survey. But all that the survey does, Mr. Sibbott, is show that a habitat has been created. It doesn't show that there's a woodland butterfly has flown all the way across the airdrome, got there.
Yeah, no, that's right. It shows the habitats there. We don't know if the wood white was there because the surveys haven't been done.
And on the question of conditioning in relation to greater crested newts, you've come up with a decision at Appendix 5 for Mr. Young, where my learned friend was making the point that the decision maker wasn't in possession of sufficient information because he didn't have information regarding a material consideration. And we've come up with the other decision, which you've seen at Buckingham. Have you seen this, which is the inquiry document, if I can take you to it?
Yes, I have seen it, and it was given to me a year ago when we postponed before.
All right.
So I'm
Let me
happy
just
with looking at it.
find that document. It's the one that accompanies the decision that I handed to you today. It's
ID 18, Inspector.
that's it.
Right, that's what we're doing.
It's actually the condition and the mitigation plan. That's
Stephen,
no, it's the same document.
Can I leave the document that you've got open at the moment to find that one? Because I'm getting this one online.
Yes,
do
you can.
Yeah, okay.
It's ID 7.5, sir. And it's inquiry document 5, presumably. I've got a spare copy here if it would help you. I've got one. Have you got it, Mr. Sibbott?
Yes, I've got it on paper.
Oh, sorry, sir. Okay. This is the actual report, sir. This is the actual one that's the ID. So we just agreed that the relevant question is whether this inspector has sufficient information to feel comfortable having regard to the habitats regulations and need to have regard to the EC directive on granting planning permission in the knowledge that if these conditions aren't complied with, the planning permission would lapse. Do you see that? So you come up with a decision with an example where the inspector wasn't satisfied, and I'm coming up with a decision where the inspector was satisfied, and can't we just agree it's open to the inspector to condition this site in the same way?
What's very different about this site is that it was an application for creation of deep sea traveller pitches on a pre-existing hard standing. And you can see that from the appeal decision that you gave out this morning. So on the front page of that appeal decision, paragraph 2, Inspector MacDonald said that she based her assessment on evidence submitted, not what was on site.
Thank you for that.
And sorry, I'd like to continue, please. In paragraph 37 of that appeal decision, which is on page 6, the inspector said that significant works have already taken place on site in the form of hard standing. The proposed works would create new access, but in the main would not create greater areas of hard standing. So what you're saying that the work in the planning application wouldn't create much new hard standing, and so the remaining works which might affect Great Crested Newts were very low.
Well, the process is that if there are newts coming from elsewhere because there are ponds round about, question is whether the development would impede the newts traversing across the land, which they would have otherwise done because of I think there were 4 or 5 ponds in that case. And so therefore the development would interfere with the newts.
The survey information was well known as far as I can gather from this, from paragraph 36.
Right.
And in paragraph 40, sir, given that the future works are unlikely to lead to any further impact, and with the condition the proposal would have an acceptable effect. Right. So that's very different to these appeal sites.
All right. Let me take a different tack. I'll leave that point, and we're just going to disagree as to whether or not the inspector has got sufficient information to condition this permission in the same way that Thatched House Farm was conditioned, even where the newts are coming from. If I could take you to its 12B7. This is another document from the parish council, and it's in the third party's evidence, 12B7 DP6C7. And it's a plan that shows the undeveloped site. 12B.7 DPC7. It's the penultimate document in a wodge of evidence. That's right. It's not the last one, it's the second to last one.
Got it, thank you.
What's 12B7? Just remind me which one I.
It's the penultimate one in the list.
Oh, well, over the water.
That's right.
Right.
and it shows a plan. Now, just with that picture in mind, can you imagine, Mr. Sibbott, that you have a different job? You are acting as an agent for some sort of recreational activity, football or cricket, yes? And they give you a brief to acquire a piece of land, is really reasonably flat, yes? For them to apply for planning permission and develop it maybe as a sports ground or whatever. And you approach me, yeah? And I say, I've got a nice piece of flat land here and it's for sale. And I've had it for quite a while. And I sell it to you and you buy it. But if 5 or 6 years ago I'd knocked down some deciduous woodland, would the creation of the football pitch be causing the loss of the woodland that I'd cut down 5 or 6 years ago?
It's certainly something which should be taken into account, and although statutory biodiversity net gain doesn't apply here, it includes the case for intentional degradation prior to development to be taken into account.
Would it be your view that anything sort of 10 years, 15 years previously should be taken into account?
The timescale is difficult, and there's no set number of years. But what I would be thinking was was felling the woodland permitted, for example, for a felling license, and was it felled for a good approved purpose?
Presume I did neither of those things, and I cut it down as a criminal offence, and I was totally irresponsible. Would your clients who wanted to develop the cricket pitch or the football pitch be responsible for the loss of the habitat? Or would there be a sufficient break in causation?
If there was a causal link, then I would advise the clients that the woodland should form part of the baseline of the assessment.
Well, if there was no causal link, because I'd been using it for a caravan site beforehand, for example. So would your clients be blamed for habitat loss?
I don't think blame is the right word, but if there was a causal link between the woodland felling and a planning application, then I would take that
You can see
account.
you can see the point that here, Mr. Simon Docherty acquires land, significant period, after the damage has been done.
I haven't got any evidence on the date of the damage, but in my opinion, it appears to be linked to the planning application to develop the land.
Well, we've got photographs from May 21 from the neighbour from Thatched House Farm. Why is it fair for Mr. Simon Docherty for the responsibility for the actions of others to be laid at his door?
The buyer should always be aware of what they're buying, and if they're buying something which causes future problems, then they should be very careful in that decision.
Well, just look at it from the other point of view then. Just imagine that this inspector takes the baseline after the trees have been removed. We've seen the photographs from 2020, 2021 showing that's the case. Just assume that the inspector is taking the baseline with the trees removed. So therefore you've got the scrubland. And how you'd say it is that the newts might still be there. Is it evidence that but there wouldn't be that loss of the priority habitat in relation to the deciduous woodland?
Sorry, I don't think I've seen the photos with the woodland felled, but I also am not sure what happened to the woodland after it felled, because typically, unless it was managed, I would expect the woodland to start regenerating again and still be a woodland in the sense of a recently felled woodland, which is a part of the UK habitat classification, and regenerating woodland would still be suitable habitat for great-crested newts and reptiles.
Because you just referred to the previous decision in Buckinghamshire, where things had already happened. And I'm pointing out the same as here, that things had already happened before Mr. Simon Doherty bought his land.
My belief is that the woodland felling was to facilitate the development, regardless of who the owner is, because the change of owner doesn't change the fact that I believe the tree felling was to facilitate the development.
But the issue that I'm raising would alter the baseline, wouldn't it?
If your contention is correct, the baseline would be a recently felled woodland instead of an established woodland, but I don't believe that contention is correct.
Well, we're going to disagree over that. Whilst we've got this plan in front of us, please, at 12B7, we know that Thomas Doherty's site is just opposite or slightly at sort of 1 o'clock to the developed pitches that we've got on the left of this picture, as I believe.
I'm not entirely sure I've got the right picture open.
Right.
Well, the one I see, which I thought was right, is headed "Sorry, interactive map," and it's just an aerial photo.
That's right. That's
the
it.
right one.
Yes.
So I can't see any overlays on it.
All right. Okay. Well, can you see the access track, which the Peel sites are to the north of, and the rest of Lydia Park is to the south of? Can you see the access track there?
Yes, I can. Yeah.
Now, can you see the oblong piece of land between Thatched House Farm and the Stovolds Road, just below the access track, before the more fully populated area on the Graves ground behind it? Do you see that oblong rectangle?
Sorry, are we talking north or south of that access track?
South.
South. So there's a rectangle that looks like it's developed into pitches.
That's
that one.
And then I've got obviously 3 open spaces, one near the road, and then one in the middle, and one on the left of my.
These are all on the south.
That's right. Yes.
The westernmost is
Yep. That's right. I don't know whether Mr. Ward has been able to find an Appendix 5 to his evidence, which is an aerial photo annotated with planning history. I'm very grateful. I hope I do the same for you. CD 3A6.
CD 3A6, Appendix 5. Yep.
And what I'm putting to you is that a large number of pitches, I think that WS Planning say not as many as the local planning authority think, but I think that the third parties, the locals, will tell you it's somewhere in the region of 30 to 50. I think there's been higher estimates of the number of permitted caravans in that area. But from my client's point of view, what he can't understand is why those conditions haven't got the concern over ecology and don't have any ecological condition attached to them, whereas he is being refused permission on a basis which, if it was good, would have been the basis for refusing permission on all of those sites too. So from his point of view, he's in the dark, he's mystified. So why is it that it's being relied on against me? And what I take from that, perhaps unfairly, is that the planning authority didn't consider it a sufficient objection to refuse planning permission on that basis.
I've not been involved in those pitches or applications or appeals south of the track. The aerial photo didn't seem to show any woodland. So that part of my case isn't there. As far as I know, there is no watercourse south of that track. I might be wrong, but as far as I know, there is no watercourse south of that track. I might be wrong, but I don't see it on the aerial photo. So that NE2 part of my case isn't there. And the aerial photo looks as if it might be short grazed grassland. I might be wrong on that as well because I've not looked at it. But if it is short grazed or trampled grassland, then a lot of my case for the wood white butterfly and the reptile habitat and other species isn't there either.
You're saying different quality of habitat?
So I'm saying north of the track has, or at least had, much higher quality habitat.
If we look at the very recent evidence from the planning authority that came in with Mr. Ward's evidence of January 2026, and again, I don't have the reference, but I do know that it's the January 2026 evidence, and it's Appendix CW24, copies of planning decisions. This is from November 2025. '24 to the supplementary evidence of January 2026. Well, when I went into the supplementary evidence, I came up with Mr. Wood's supplementary evidence from last year. So I didn't come up with the January 2026 supplementary evidence when I was looking for it online.
So you're looking for CW24, aren't you, Stephen?
That's right.
So he's right. That's where it is.
That's right. Thank you. And so the point of the question is that the authority, with all these permissions, have been prepared to grant permission without regard to the need for any prior survey.
So the two decision letters don't make it clear to me whether there was prior survey or not. But if you say there wasn't, then I've no reason to dispute that. But neither do the conditions require further survey. So without being involved in those sites, I would speculate the local authority thought there weren't protected species issues to be dealt with.
I'd like to take you to the EC directive, I'd like to take you to the EC directive, which is at the back of circular 2 06/2005, and it's Annex F, and I've got it at page 117 in the large PDF, which comprises your proof of 357 pages.
I've not got that on paper, so give me a few seconds to find it electronically.
Page 117.
Yeah, it's in Appendix 2, Inspector, but the page numbers aren't numbered in the way my learned friend suggests. So are you looking at the PDF page number, Stephen?
That's right, electronic page 120, 117, it's 125 for the actual article.
But it was
12.
Annex F, was it that you were looking at? The directive.
That's right.
43, yeah.
So
That's got 74 in the bottom left-hand corner.
That's
Oh,
right.
yeah, Appendix 2.
That's right. It's the circular, it's the back of the circular, and it's Annex E,
Annex E or F.
and it's page 60. Sorry, just a minute.
Because I'd said F, because I thought
Yeah,
you wanted
it's F,
92.
it is F, it's
Yeah.
definitely F.
Right.
So on the internal pagination of that circular, it's page 74.
It is, yeah.
That's right. And it's page 82 is Article 12. So the situation is that the habitats regulations requires the decision maker to have regard to the contents of the directive. And the directive is saying that member states shall take requisite measures to establish a system of strict protection for animal species listed. You see that?
Are you on page 84?
Well, we
now?
know that. The point, the question is this. The question is this. How do you establish the presence of the species? Because you don't know that the woodland white butterfly is there. You've just said if it's there.
Yes, I don't know if it's there, but the wood white isn't one of the European protected species which the directives refer to. So that would be great-crested newts and bats in relation to these appeals.
Well, I looked at your document on guidance for selection of sites of nature conservation importance in Surrey, and it was May 2008, and I thought, well, that's a long time ago. And so I did a Google search on guidance for selection of sites of nature conservation importance in Surrey, and I found a more recent one that was issued in 2024. Are you aware of that?
I wasn't aware of that. My proof was 2024, so it may have come out after my proof was written.
Well, that had a section on how you determine the presence of a protected species. And what I suggest to you that there isn't enough evidence to show the presence of the white woodland butterfly on this land.
If that was talking about ways to show the presence of the wood white, then that would be in the context of selecting it for the site of nature conservation importance. And no, I agree that appellant surveys have not been carried out to establish its presence.
Well, what we do know is that the owner of Thatched House Farm is trying to encourage them.
Yes, and we know he says they are on his land, which is very close by.
And he's put down how many square meters of, was it 55?
I think it was 55 square meters of additional habitat.
Yeah, and we're offering to put down 300 and, how much? Was it 25? I think you gave the meters, didn't you?
I recall that Mr. Wood's proof offered a 1 metre strip of grassland around the site periphery, so adjacent to fencing for Appeal A and adjacent to the hedge for Appeal B, and I discussed that in my.
I thought you said 325 square meters. Was how you added it up. all the way around the perimeters.
I can't remember saying that, but if I did, then I've forgotten.
Well, that's how you calculated the amount that would be provided. And I'm putting to you that I don't know how many times you come across the sort of plants that they eat. Is it is it the trefoil? What are the plants that you found on the edge of the site?
The examples given were meadow vetchling and bird's foot trefoil.
Trefoil, thank you. And how frequent would you come across trefoil?
It's found scattered throughout the grassland, as far as I can tell.
Exactly.
The remaining grassland.
And there are pictures of it, aren't there, in the documents along the side of the road? There's a so if we can go to the wood white fact sheet that's attached at appendix 6, 8, 9 of your proof.
Yep, got that.
Do you have it, sir?
Yes.
And on the second page, it's a habitat management for the wood white.
Yep.
And it says connectivity between existing breeding habitat can be improved by widening overground shaded rides, scallops and box junctions, and can be created to make the breeding habitats more open to create refuge habitats away from the verge edges. And then on the middle column of that page, features such as turning circles and loading bays can also provide good breeding habitat. So why can't a turning circle on our site be a good habitat?
What I've seen proposed is a 1 meter strip, rather than any turning circle or larger area of habitat, and the 1 meter strip which would be very shady
And then there's
and unlikely to support those species in the long term.
and then there's a picture at the bottom of greater bird's foot trefoil on Ride Edge. Do you see that?
Yeah.
So if it's so common, how can you persuade this inspector, because you saw it, there must be a woodland white butterfly there? It just doesn't follow, does it? Because you see what they eat or feed from. When it's so common, it's all along the side of the roads. Could be in Scotland. Doesn't mean you see that there's a woodland white butterfly. It's a correlation of circumstances that you're relying on, isn't it?
Well, the wood white is particularly rare, and its southeast distribution is based on Chiddingfold wood and the surrounds. So no, it doesn't live everywhere those plant species live, but it doesn't need those plant species in particular circumstances.
But if the planning permission included the ecological enhancements that we're suggesting, and there was the planting of this particular vegetation that's conducive, similar to what Thatched House Farm has, but a lot more of it, all the way around the perimeters, then that would be an enhancement, wouldn't it?
Well, the Thatched House Farm, 55 square meters, was set within grassland, and it wasn't a narrow edge, which was very shady, set within a domestic setting.
Well, it could be fenced off.
Well, it's already fenced on or hedged on
No,
one
but it
side.
could be fenced off from a domestic activity, is what I mean, rather than having trampolines on it or something. You're nodding. I think I
Well,
need a yes.
in theory, yes, it could be fenced off.
It could be fenced off. And
If one believes it could survive the
why,
heavy shade.
why is it shaded if it's south facing?
Well,
Why do you say it should be shaded if it's south facing?
Most of the pitch appeal B, it runs north and south, so there's very little of it is south facing. And there's also shading from caravans and day rooms and so on.
Well, the inspector will see with his own eyes when he's walking up and down the edge of the pitch next week in the bright sunshine, your point that it's going to be shaded. And I put it to you that it's very open to the sunshine.
At the moment, the proposed hedging around appeal site B isn't there. So what's being proposed is something different to what's now.
That's a good point, actually. Perhaps we should look at the location plan that came with the submission, sir, which was the proposed planting for the appeal site. Which came with the plans. Thank you.
I have a few for field Bs.
That's right.
CD 7B.4. Is that the one?
Thank you. So if the inspector has this in mind, with the further capacity for the trefoil and the other vegetation that you sound all, is it meadow vetching? If we go back, the wood white fact sheet, it's got meadow vetching, greater bird foot trefoil, bird's foot trefoil, and tufted vetch. And I believe you on site detected a couple of those.
Yes, I saw the bird's foot trefoil and the meadow vetchling.
Yeah.
Not on the appeal site, but
Well,
in the
my first point is just because you see them doesn't mean they're there, because you can get that planting everywhere. Those plants.
No, I agree. We haven't got that information to know if they're there or not, and that's part of my case.
Right. Well, that's where we go to the tilted balances. You don't have enough information to know whether it's there or not. My argument was, how do you establish the presence of a species? And even your decision, Appendix 5, which is Mr. Young, the planning inspector still went on to the tilted balance, didn't he? So it's not just the fact that there's no survey done isn't a reason for refusal, because there's also other factors on the other side of the equation, aren't there?
I think that's for the inspector to make that balancing act. And while we're talking about that proposed strip of grassland, could I also mention its management? Because I'm aware in statutory biodiversity net gain, although it doesn't apply here, it's quite clear that that the vegetated garden habitat, which is all one can propose in domestic settings, isn't open to planning control. So it has a very low distinctiveness, and one isn't allowed in that situation to provide higher value habitats because its management can't be secured.
Well, being practical, Mr. Sibbott, we know that there's a planning decision that's being taken, and we know that the planning condition is being proposed, and we know that the planning condition can require the maintenance of the planting. So here, no evidence of disturbance and no evidence really of interference with the species. a woodland white butterfly. Is that correct?
Yes, I mean, that's the whole issue.
Well, that was the reason for refusal, and you're agreeing there's no evidence for it.
Yeah, so the lack of evidence is the problem.
It makes it more easy to outweigh, doesn't it?
If surveys had been carried out and found that it was absent, then we wouldn't be discussing it.
And it's also true to say that insofar as it affects the foraging habitat of bats, that was more linked to the trees, the presence of the trees.
Yes, the bats mostly forage along the edge of woodland or along the edge of
That's
trees
right.
or along hedges rather than open ground.
Well, if the inspector is with us on the basis that Simon Doherty wasn't cutting down trees, then the other point is whether we're interfering with the habitat of greater crested newts. Wasn't a reason for refusal, but it can be dealt with by condition, can't it? As we've seen with the Arbtek mitigation plan.
It is the same issue as the wood white, in that we haven't got the information to be sure that newts are either present or absent. Because the pond 110 metres to the west at Thatched House Farm wasn't surveyed, and if that contained newts, they may have colonised the pond by the blocked drainage ditch immediately next to Appeal A.
Well, that is again exactly how it was dealt with in the Buckingham decision, where they had to go off and do the proper investigation in order to include the extent of the refuge or refugia that were necessary. But I'm going to leave that subject under pressure of time. Can I, sir, leave the definition of ordinary watercourse? Because I'm not sure I accept that the terms of the policy were envisaging this sort of watercourse rather than the basin. I think I'll leave that to submissions. But from Mr. Simon Doherty's point of view, he needn't have residential development within the required buffer zone of the restored watercourse, need he?
I've not seen any proposals before the inquiry to restore the watercourse and restore the 5 metre buffer beside it.
Well, I'm not sure that the policy was intended to cover this watercourse. I think it was for the rivers and the canals, but that's how the policy is drafted. It'd be some legal submissions.
As that's been mentioned, sir, may I reply to that? So main rivers are those designated by Environment Agency as main river, and they're the big rivers which Environment Agency directly manage. Ordinary watercourses are every other watercourse, which are regulated by the local lead flood authority.
But I don't read that from the local plan policy, do I?
It doesn't define them, but it uses those phrases, main river and ordinary watercourse, which are defined.
I'm trying to think of how many residential settlements I know within such distance of a stream, but never mind, or a watercourse. If I could just come back to the point about Article 12 of the directive. Would it be safe to say that there has to be some evidence that you're interfering with the breeding or the distribution or the abundance of the population? Because there was a case in Canterbury where they put a bus route down an old disused railway line, and the bats were being disturbed, and the House of Lords thought it was okay to grant planning permission as long as there wasn't a criminal offence being committed. And my point to you is that we haven't reached the threshold of putting the species at risk. The fact that there might have been the casualty of an individual animal doesn't trigger breach of Article 12.
If I remember that case right, with the guided busway, the buses were driving along a route which the bats flew past, So every so often a bus would go where a bat was foraging. And I think the decision was that disturbance was too small to trigger harm to the species. Whereas
Well,
the
it's
point
not affecting the long-term distribution
Well, he
or
hasn't finished
abundance.
answering the question yet, Stephen.
Sorry.
So the point of the directive, as you read out, is to make sure member states take the appropriate actions to preserve those species, and that they do that through legislation and through planning policy.
Well,
So where we mention European protected species, which are those relevant to the directive, which in this case are great-crested newts and bats, then the directive is met by planning policy ensuring those species are taken into account during planning applications.
your point that the casualty of development may have been a newt that was in the path of the development is not the same thing as Article 12, which is concerned with the distribution and abundance of a species. And we have to be practical here, that steps can be taken to protect the greater crested newts without affecting the long-term abundance or distribution of greater crested newts in the area.
So the way that works in planning is that if newts or newt habitats are due to be harmed by development, then one can apply for a mitigation license to Natural England to safeguard the newts in that application. And there are two different ways of doing it. The standard way is to have full surveys to understand the abundance of newts in nearby ponds, then to ring fence a development site prior to development and catch out the newts and move them to safety before development commences. And the second way of doing it would be to apply for a district license in which one makes a conservation payment, and then the site may be destroyed without further safeguard of the newts, because the conservation payment goes to improvement works elsewhere to compensate for that newt population change.
And the fact that it was done next door at Thatched House Farm proves it can be done here, conditioned.
I think the thatched farmhouse application we discussed earlier was a bad permission and they didn't do it right. So that doesn't mean it should be done wrong here too.
Well, they knew there were newts there and they conditioned for newts.
I have to go back and check. I remember a condition for a reptile survey, which
Well, it was also true, Mr. Sibbott, that the Surrey Wildlife Trust saw the ecological appraisals that were produced on behalf of these appellants and gave the permissions a thumbs up. They were satisfied with the appraisals, weren't they? Surrey Wildlife Trust, in this case.
I can't remember exactly what the words were. So can you find out the document number? Sorry.
No, it's the Surrey Wildlife Trust consultation response.
Application, so the Surrey Wildlife Trust consult on this one.
That's right.
Yeah, not that that's right. Gave a thumbs up to it. I think it's in the report.
So it'll be in the.
Maybe it's in consultation. No. I thought it was CD5, consultee and interested parties. Well, I'll leave that one under the pressure of time, but it may be that my own friend, Mr. Lintott, will come back to that if I've got it wrong.
I want to know what I'm coming back to.
Well,
first.
it's just
So-
the Surrey Wildlife Trust saw the ecological appraisals. And didn't put in the objection. The basis of the objection is a reason that the authority came up with on the woodland white butterfly. That's the reason for refusal, is linked to the woodland white butterfly.
So this hasn't got anything to do with the thatched house farm one. That was something different. This is just for this one.
Yeah.
Yeah. Okay.
I'll leave it at that. So, I mean, I've deliberately cut it short, sir, in order to try and progress matters.
So if I can answer that point, sir, my view would be is that you're in the best place to decide if you think my evidence is credible, or if you prefer what was in that letter, should we find it?
Your evidence is exaggerated, isn't it, Mr. Sibbett? Because you take the view that planning permission should be refused because there's loss of habitats. You take the view that planning permission should be refused because there's a lack of survey. And you know that this planning inspector has to balance it against other matters.
You've summarised my point of view, but I don't agree. It's exaggerated.
I also happen to have the Thatched House Farm ecological survey, if that would be of interest, but I've got no further questions.
Thank you, Mr. Cottle. What are you suggesting about the Thatched House Farm survey? Because it's
Well,
It's
Mr.
not-
Sibbett has just introduced the topic that the planning authority weren't doing the job properly. And it's a very thorough survey. The planning
I think
authority
under
were
those
doing the job.
circumstances, sir, it should go in, so that you can make your own appraisal, bearing in mind Mr. Sibbett's condemnation of that approach.
I'm not sure. It's obviously a document that the parties were aware of beforehand. If Mr. Cottle already has it, and there's been time for it to come in earlier.
That's right. The man, Mr. Herman, wrote in 2023 saying that we've just got a planning permission and we had an ecological survey done.
Yes.
And that's what was a thread of the trail that I picked up. But I'm not seeking to put it in, but I'm just saying that since Mr. Sibbett seems to be undermining the strength of the planning authority's decision, we do have that appraisal, should it be of interest.
I think you should have it, sir, because what's new now is that Mr. Sibbett appears to be criticising the council's approach to conditioning that planning consent, which of course we say is consistent with what we think you should do. In this case.
That's a view that could have been taken earlier, Mr. Masters. That's it. That it was of relevance and interest to this case.
It's not that, sir. I didn't anticipate for one moment Mr. Sibbett would be saying
No,
council got it wrong, which is new.
maybe not. But I'm not really looking to collect extra documents at this stage, Mr.
Okay,
Masters.
I understand, sir.
Before I go to you, Mr. Masters, for any questions on any other points, just want to go back, as I know some other members of the parish council have come in. I just want to go back to the point I raised just after the lunch adjournment concerning the flood risk evidence put by Mr. Woods for the appellants and appeals A and B. I mentioned then that I hadn't gone to the parish to see if there were any questions, but I just wanted, because there wasn't anything that I could immediately see in the joint statements in terms of it being raised as an issue. But I did notice over the lunch adjournment that Councillor Britton, in his statement for the appeal, had made a reference to drainage. So I just wanted to check before we lose Mr. Woods whether there were any questions that any representative of the parish did want to put to Mr. Woods. Well, okay. Now I know that's the case. It's just a question of how to organise it.
I would recommend that we try and finish with
Yeah.
Mr. Sibbott in cross-examination at least.
Yes, I don't want to interpose.
And then for Mr. Woods to answer those questions that the parish council have got for him.
I agree, but I think I overheard Mr. Woods say that he might not be here tomorrow.
I won't be here tomorrow. And that was on the basis of the programme.
I understand that,
set
Mr. Woods.
out.
Yeah,
And I've got other arrangements. I've got
Yes.
childcare duties I've got to do tomorrow.
that's entirely understandable.
But there are opportunities, I think, to possibly move things around a little bit in terms of the programme, because we've got Mr. Rowe that won't be speaking on 2 occasions. And
Will you be here on Friday?
I'll be
Yes,
on
yeah.
Friday, so yes.
So we don't get to you this afternoon in terms of the questions from the parish. Is it Councillor O'Sullivan?
Councillor Sullivan?
Yeah.
Yes, I will have a problem with Thursday and possibly Friday to be able to speak if it's very little questions.
Well, it doesn't have to be yourself, Councillor Sullivan. One of your colleagues could put the questions. I don't really want to interrupt the session that we're in now. I just want to make sure that there is an opportunity if there are questions on flood risk. Then it may be that we get to it later this afternoon, but if not, if somebody from the parish could put the questions on Friday, that would be helpful. Okay, can we leave it like that? Thank you. Right. Mr. Masters, it's,
Yeah, Mr. Sibbott's going to move round, sir, so I can.
oh, of course, yeah.
While Mr. Sibbott does that, can I just say that my learned friend indicated that his cross-examination of clients of the appellants might go shorter than anticipated. And if it does go shorter tomorrow, whether we can countenance Mr. Ward giving his evidence in chief, which I'd be happy with, subject to Mr. Woods' view, to countermand me in Mr. Woods' absence, because he'll just be going through his written evidence. And so we could perhaps use tomorrow afternoon for a bit of Mr. Ward's evidence.
Well, I'm not sure about that, but we'll come back to that, sir, at an appropriate time, I think. Good afternoon,
It's
Mr.
matter
Sibbott.
for my learned friends, I suppose, but usually I'd want my planning witness with me whilst cross-examining planning evidence of the other side.
In chief.
Yeah, I know, but I'd want him here too.
Yeah, but Ward would be giving chief, wouldn't he?
Well, let's review things later on, Mr. Cottle.
Good
You
afternoon.
set up Mr. Sibbott.
Yes, thank you.
Good afternoon, Mr. Sibbott. Mr. Sibbott, if you go to your proof of evidence, and I want to go to your paragraph 2.3. And do we agree that what the inspector needs to consider here is the appropriate baseline?
Yes. Yeah.
Yep. You can't give any evidence, can you, about the date and who took down any trees? Because you've already said that. Could you say yes or no?
I don't know the date when trees
No,
are cut
thank
down.
you.
No, thank you.
You can't give any evidence, can you, about the date or whom filled up any watercourses, can you?
I don't know exactly when or who. No, that's correct.
No. My clients, and so I'll go first of all for plot one. Thomas Delaney, Thomas Doherty, sorry, forgive me, why I said Delaney, I don't know. Took down 2 dead ash trees and no more when he developed the site. And I think his planning application was initially dated in 2022. Mark and Matthew Doherty inherited their site with no trees, did nothing to the watercourse because at that stage it was all hard surface.
Mr. Masters, I'm just getting a little bit concerned about the fact that you're dealing with matters which perhaps should be given in evidence by your clients.
Well, it is going to be given in evidence tomorrow, so.
Yes, well,
and
that might be the time to deal with what the
but-
site was like when they acquired
well,
it.
I have to put to this
I know-
witness what they're going to say, sir.
Well,
So that he understands.
we don't know what they're going to say to, particularly some of them are giving oral evidence until they say it.
Well, I have to put, no, I have to put, what I
Perhaps you-
say is the
You have to put a
baseline.
scenario to him. I don't think you can actually give substantive evidence.
Well, he can accept it or not. It'll be, I'm not giving the evidence. I'm just saying what they're going to say. So, the baseline, and we can see what the baseline was because we can see, the reports, the Arctech report, for instance, the baseline of the 3 sites I've referred to were all hard serviced. And that's the baseline they took because that's what they saw when they went first to the sites, okay?
I disagree. What Arctech saw when they went to the site was that the baseline for the assessment, the baseline should have been the pre-development.
Well, no, I understand that's
status.
the distinction between us. The difficulty is that the baseline that Arctech took was what the conditions they saw at the time that they were making an assessment prior to the planning application being put in. All the sites were hard serviced, and that's a decision for the inspector, isn't it? What is the appropriate baseline here? Because one thing we don't do in English law is we don't penalise developers for mistakes made by previous developers. If there's something that previous developers have done, the local authority have other powers to deal with that. You weren't involved, were you? And can't even give a date when the trees were cut down and the ditches were filled in, were you?
Firstly, I think the planning status of a site doesn't reset when it's sold to a new owner. So the fact that somebody else facilitated the development rather than the appellants here is not irrelevant. But
It is not irrelevant. Did you say?
it's not relevant to
Oh, it's
planning
not relevant.
that somebody else started the development. But I know the description of the development is something you wanted to discuss separately. But in terms of ecological baseline, I know for Appeal A, the application form in CD 1A.1 included as a description of the development formation of hard standing. And that had not been started according to the application form in October 2022. So if that was filled in correctly, then the development under that application.
Did you
is
answer the
clearly down to
question,
that.
Mr. Sibbott? I'm just, you can't give any evidence, can you? I'll say it again, as to when the trees were cut down and to when the ditches were filled in, and 3, when the hard standing originally went down.
I'm trying to answer that question, sir, in relation to the planning applications.
Could you just answer my question? Can you give any evidence directly from your own knowledge as to when these things occurred? Yes or no?
Well, I wasn't there to watch it.
So is that a no? Could you just appease me and use that term so I understand what your evidence
No, I
is?
don't know exactly when it happened or who
Thank
did it, but I'd like to continue, sir, with my list. So for Appeal B, the design and access statement on CD1 B3, the 3rd paragraph on the 1st page says the site will be laid to stone. And the application form, which CD1B1 said the development had not yet started.
We know from the start of this inquiry, the question the inspector asked me whether it was a retrospective planning application. Everybody knows that it was a retrospective planning application because of the work was done. And that's the basis upon which this inquiry is going. So I'm not going to go back over that. Can I just go to, sorry, no, if you want to say something, please say it.
Could I continue for Appeal Site C and D, please? So the application form for Appeal Site C CD1, C.1. On page 4, the description of the development included hard standing to provide parking, part retrospective, and the development started on the 21st of June 2022. And similarly for appeal site D, and the application form CD1D.1, again, the description of the development on the 4th page of the application form. The development was described as hard standing to form parking, part retrospective, started 21st June 2022. So to me, that gives an understanding of the dates the development started and demonstrate that the hard standing is part of this development. It wasn't something that happened previously by somebody else, which became baseline.
Forgive me, you can't give any evidence when that, as to the date that hard standing was put down and whether it was actually there prior.
Inspector, he's asked that question 4 times now,
I
and he's had the answer
You,
to
you,
it.
you have, Mr. Masters.
I have, but I'm going to go on.
Mr. Masters, you're not going to go on. You've asked the question and you got your answer.
I have. The
And
answer
then,
you-
and then it was qualified, and
Yeah.
Mr. Sibbitt's entitled to do that.
I'm not saying that, sir. I've got a second question. You've just given the date of the 22nd of June. You can't say whether or not the hard standing was there before that date, can you? Can you?
For appeals A and B,
Yes.
the development had not yet started
Sorry,
on
can
their
you just
dates.
answer the question? You just gave a date
Mhm.
relating to Appeal C and D, the 22nd of June, 2022. You can't say whether the hard standing was there before that date, can you?
No, I can't
Thank you.
because the application isn't clear on when the hard standing was laid.
That's the point. You can't give any direct evidence as to when the baseline was, therefore, can you?
There's certainly a sequence of aerial photos, I think, in my brief showing when woodland was cleared for appeal site
And what
A
date do you say that was?
and when they were cleared.
And what date do you say that was? Because that was prior, wasn't it, to the 22nd of June, 2022?
This witness has no personal knowledge of the matter, but the neighbour, Mr. Thatched House Farm, has got some photographs who did have some personal knowledge, and that's the position.
So I'm looking at the Arctic report, which is CD 2A.6. Yes, it is, sir. Yes. So I'm on page 16. So on page 16, that there are 2 aerial photos. The top one, figure 10, shows the 2018 Google Earth photo with none of the appeal sites having been commenced. And the bottom figure shows the 2022 aerial photograph, which shows site A outlined in red, but it also shows the appeal sites B, C and D with hard standing at that time.
Yes, but what that doesn't tell us, does it, those aerial photographs, is when hard standing appeared. It shows that it was there in 2022, but it doesn't say when it started. Have you got any evidence, and you've heard what the neighbour has said as to when it started, to contradict the neighbour's evidence?
No, I've said previously, I've got no personal knowledge of exactly when it went in, so I haven't got anything to contradict what the neighbour or other people have said.
Thank you. So therefore, the baseline for this development is in 2022 and not prior to that, when hard standing was laid down.
It's just not correct. And it's not a question for the witness anyway, Kim. What
Sorry, so do you know, I haven't interrupted anybody so far. I think if my learned friend could, unless you sort of think, Phil, I've asked a question that's not correct, I've really tried to be patient with this witness because it's quite clear all along that he couldn't give direct evidence from his own personal knowledge. Should have been a very simple question.
Mr. Sibbert's established that and given you an answer from his own personal knowledge,
Yes.
Mr. Masters. So let's move on.
Yes, thank you, sir. So, Mr. Sibbert, the next question I want to put to you is that you said that the harms here come in about 4 categories. 1, harm to the trees, the deciduous grassland. 2, sorry, to the deciduous trees. 2 to the harm to the grassland, and then 3 to protected species. And you referred in particular to the great-crested newts, the moth, and in passing to bats and to badgers. Yes? Let's just remind ourselves what the reason for refusal was, shall we? Reason 3, in the absence of site-specific ecology survey, it is not possible to conclude the impact of the proposed development to protected species would be acceptable. And there's a quote from anyone. So it's nothing to do with biodiversity or loss of woodland. The reason for refusal was specifically relating to protected species, wasn't it?
Sorry, I'm thinking about it because I haven't got the decision notice in front of me, but from what you read out, then yes, the refusal was about protected species.
Yeah, and you've decided in your evidence of this inquiry to add essentially all sorts of other concerns you have relating to biodiversity. Let me ask you this in that context. This isn't a site, is it, where the biodiversity net gain rules apply, 10%?
That's right.
The only policy is one of enhancement. It could be 0.1 of an enhancement to biodiversity. That's the planning issue for the inspector here, isn't it? In relation to biodiversity issues.
That's certainly part of it, but where I recognise other harms, such as the woodland habitat of principal importance and the watercourse, then I have a professional obligation to bring it to your attention, sir.
Well, I hear what you say, but I'm pointing out to the inspector it's not a reason for refusal, and it's something new you added in your evidence for the very first time. Secondly, if we go to your evidence, and it's been put starkly by a learned friend, but if I may go back to it, your case,
Mr. Masters, if it's something that's been put by Mr. Cottle, there's no need to revisit.
In this instance, I have, so bear with me for a second, because it won't take long.
Well,
Paragraph
whether
3,
it takes long or not, I don't want the same question.
no, it's not quite the same question. Paragraph 3.6 of the proof. Sorry, it's not 3.6. I'll just make certain I got the right paragraph. Sorry, it's 2.4. Your case, in a nutshell, is this at the bottom of 2.4, isn't it? The lack of adequate survey work means that the impact on these species cannot be certain, the inadequate information to allow an informed understanding of the impacts of the unauthorised developments, the harm to habitats which you've added in, potential harm to species, which was the reason for refusal, means that each appeal should be dismissed. So your place, the mere fact that you haven't done the surveys in advance, adequate surveys in advance, the surveys were done, means that planning permission shouldn't be granted. That's your case, isn't it, Mr. Sibbott, in a nutshell?
Yeah, yes. Yeah.
Thank you.
Yeah.
So I'll examine the proportionality of that in context, because what I'd like to do is to go to your 3.13, where you quote from planning practice guidance. And I have a sheet of the planning practice guidance here. So I wonder if it could be handed out so that Mr. Sibbott and everybody else has it. This is taken last night from the current version, so it's up to date. It's paragraph 19, sir, from the PPG on how can biodiversity and geodiversity be taken into account in preparing a planning application. And you quote, don't you, in your 513 from paragraph 1 of that, which says an ecological survey will be necessary in advance of planning application if the type of and location of development could have a significant impact on biodiversity, and existing information is lacking on adequate pre-application discussions that can help. Now that relates to biodiversity, doesn't it? Not to protected species.
Protected species are part of biodiversity. It doesn't just mean statutory biodiversity net gain.
Well, okay, that's your answer. But for some reason, you don't quote the very final paragraph, do you? And I'd like to read it to you, because it goes to this to a very pressing issue of proportionality. As with other supporting information, local planning authorities should require ecological surveys only where clearly justified. Assessments should be proportionate to the nature and scale of development proposed and the likely impact on biodiversity. So that's the test and concerns that the inspector has to look at in this case, isn't he? He has to take a proportionate response to these issues in the context of the development and in the context with the potential harm that is involved. Do we agree with that?
Oh yes.
Now, proportionality is something you know well, don't you? Because you're the Sibbott, weren't you, that designed the back tunnel for the 100 million HS2.
I've never been involved in HS2. That's nothing.
Sorry, weren't you involved in the back tunnel approach? Aren't you the Nick Sibbott who used to be at Lakeland Designs?
It's absolutely nothing to do with me.
Okay.
I've not heard of Lakeland Designs.
Okay. You're not the same person, but okay, not to worry.
I'm not aware that there was somebody else with my name in
There
in the
is,
UK.
I'm afraid.
It's just there.
So, yes, he's an ecologist. Absolutely. Don't worry. I got that wrong then. But anyway, but proportionality is the issue here. Okay. So let me see if I can explore this a bit more, because most in another context. So first of all, if I could go back to your evidence. If I could go to your to maps that you looked at with the inspector.
Okay. Yes, my figure 1 and figure 2. Yeah.
Okay. Now, first of all, the
Which one are you looking at?
I'm looking at yeah, I think I'm looking at number 1, sir.
Okay.
I'm looking at the map that identifies the deciduous woodland.
Yeah.
Okay, which you went to with the inspector. Now, in relation to site 1, that falls mostly within inside the deciduous woodland, doesn't it?
Appeal A, yes, it is
Sorry.
mostly in the
Yeah, whereas-
deciduous woodland.
Whereas Appeal C and most of Appeal D is outside, isn't it?
Most of Appeal D is outside. A little bit of Appeal C is inside, where its access joins the main track.
Yeah, sorry, I think it's the other way around. Appeal C is completely outside. Appeal D a little bit where the access track, but not where the living falls inside it. Yes?
Appeal D resulted in the loss of part of the woodland. Appeal C, the northern one, its access to the main track passes through the former woodland. So Appeal C is also relevant, but only a very small part of Appeal C's
Right.
red line.
So in reality, the majority of Appeal C and D falls outside of any effect whatsoever on the woodland. You've already got my point, but the baseline has to be taken from the day we put the planning applications in, when there was no trees done. But let me just ask you this: were there any restrictions from anybody in cutting down any trees on this land? Any TPOs or anything else?
I'm not aware if there were any tree preservation orders,
No.
but certainly a felling license would be required for cutting down more than, I think, 5 cubic meters of timber in any calendar quarter
Yeah,
year.
and are you suggesting a felling license was required here? Have you done the calculations? And were you involved in how many trees were cut down? So can you say for certain whether a felling license was needed or not?
I haven't done
No,
those calculations.
So please don't speculate.
Mr. Masters, can you stop jumping in while Mr. Sibbitt's answering your questions?
Oh,
It doesn't help me taking notes. It doesn't help you getting a proper answer.
I'm grateful, so I will do that. Mr. Sibyl, I'll continue. So there was no restriction that you can point to lawfully for whoever was the owner at the time for cutting down any trees, can you?
The lawfulness would come from it being part of an intentional unauthorised development without the benefit of planning permission.
No, sorry, there isn't any in law. Intentional unauthorised development may or may not be a planning issue. It is not it's not a criminal issue. So I'm going to go back to it. There is no criminal restriction against the owners in this case from cutting down any trees on land they own, is there? That you can point to.
So if the
Could
premise
you answer the question first? Then you can give you a caveat.
So if the premise is correct that no felling license was required, then the trees could be felled without one.
Thank you. And you don't know one way or another, as we've just established. Secondly, in relation to the grassland, okay, an owner can put horses on that land at any stage and they can eat the whole of the grass, can't they? And there's nothing that's stopping an owner managing his land in a way that doesn't retain grassland at any stage. That's right, isn't it?
Yes, great grazing isn't normally under planning control and doesn't normally need a consent from anybody.
No. But it's not just grazing, you can mow it. If you want to mow your grassland or tractor it, you can do that. There's no restriction, is there? I mean, what we're looking at is a question of proportionality here. I mean, you as an ecologist would like all these areas to remain untouched because you consider that to be, quite rightly, a benefit in ecological terms, yes?
I think outside this appeal, how the owners manage their grassland is a matter for them.
No, I'm asking your opinion. I'm entitled to do because you're making opinions on this. Okay, so your opinion is that people shouldn't touch grassland of this type ever because it's better for the ecology for it to remain untouched. That's your position, isn't it?
My general concept about life is that if land is important for nature, I would prefer it to be continually managed for nature. And prior to this appeal, I had no specific knowledge of this
Yeah,
specific
no, I
site.
know, but the answer then is yes. That's your general inclination, quite properly put as an ecologist, that it shouldn't be touched. But of course, there's a proportionality to that approach, isn't there? One has to develop land, and one has to use land, and sometimes ecology and development clash to a certain degree, and there has to be a balance. Yes.
Yes. So the proportionality issue here is that there's a long list of protected or rare species. And I don't need to run through them all again, but
Well,
we've
no,
talked about
I'm
them.
afraid let's come to those.
And there's the loss of the priority habitat. And there's the loss of the woodland. So that's a big impact, and it's proportional to make sure those impacts are properly understood.
Let's come to that. Let's look at the great crested newts first, because there was the survey on the 25th of June, okay? The eDNA survey. But what happens is that they look back for great crested newts DNA, don't they, in the watercourses? Right. And we know that in the 2 watercourses they surveyed, they found no DNA, did they?
That's right. In the one they surveyed, they didn't find the DNA, and the other one was dry, so that they couldn't search for it.
And they concluded that because they couldn't find the DNA, it was unlikely that they were likely to be newts in ponds bordering the site, because otherwise they suspected you'd find DNA in that, because that's the way that newts work. They go from one site to the other. So if they didn't find it in one, it was unlikely to be in others nearby. That was their conclusion, wasn't it?
I'm not sure I would agree with that, because...
Could you just answer? That was their conclusion, wasn't it?
Yeah, I don't agree with that conclusion.
No, I understand you don't agree with that. But that was the conclusion of the surveys.
The question's been answered quickly as you wanted. Now, Mr. Sibbitt's entitled to give his rider.
Yes.
So if I explain, sir, the pond immediately to the west of appeal site A was new at that time. It had only been there perhaps a couple of years at the most. So newts may not yet have colonised it if there were great crested newts breeding in other ponds in the vicinity.
But you see, that's a recipe for madness. What the survey found, quite positively, that there wasn't any newts, and it was unlikely, if they weren't in this pond, they were going to be in other ponds nearby. Now, you can argue, well, that might have been right at the time, but it doesn't mean they won't colonise it in some future date.
But let me also point out what they said about newts.
I can tell you. As neither watercourse supported populations of individual great crested newt, it is considered likely the species is absent from the site and the habitats immediately surrounding the site. That's the quote.
So I'm looking, sir, in CD 2A.8, which is the Darwin Ecology Newt Survey we've looked at before. We had it before in my
evidence. It's the 25th of June 2024 survey, so that I referred to.
CD 2A.8. Yes, sir. So on the third page, under the heading recommendations, the first paragraph under that recommendations is exactly what Mr. Masters said. Is not neither water body supported populations or individual newts. It's considered likely this species is absent from the site and habitats around it. But the next paragraph, sir, the second sentence, however, the habitats within the wider site area, comprising the woodland, scrub and longsward habitats which border the site to the north and east, should be enhanced and managed to increase the opportunities available to great crested newt and common amphibians in the local area. So they're now saying that there are great crested newts in the area.
No, we're not. What they're saying is there are no great crested newts, but the habitats should be advanced so that they could be encouraged in the future. This report makes it quite clear that there are no crested newts. If there are no crested newts, the fact that there might be crested newts in the future isn't the point. It's what's the point. It's what the baseline shows. The baseline of this evidence clearly showed no crested newts, didn't it, Mr. Hibbert? You can have it both ways, but at the end of the day, we have to have a baseline. We have to have a date when things aren't, not when they may be in the future, but when they aren't at the moment. And this evidence clearly showed there weren't any great crested newts when these surveys were done in June of 2024.
I find it contradictory, sir, because yes, of course it shows there weren't any newts in those ponds which they surveyed, but it doesn't say there weren't any newts in the pond they should have surveyed but didn't, which was 100 metres to the west.
You
And let me finish.
Yes.
And there's no point recommending an enhancement of their habitats to increase the opportunities available for great crested newt if they think there aren't any, because you can't enhance it for them if they're not there.
There's a pattern developing here, you see. When there are reports relating to neighbours' sites and planning permissions granted on a condition, you say, well, I don't agree with that. When there are surveys done in relation to this site, which show no newts, you say, well, I don't agree with that. I mean, that's your position. If it doesn't support your argument, you don't agree with it, do you, Mr. Sibbard?
If I had been involved in the neighbouring site, I would have given them my same professional opinion on what was needed for it.
You see, what the inspector has to go and is the actual evidence that was done and the surveys that were done. Frankly, your opinion at this stage doesn't matter. The survey, can you just answer this question, clearly showed, according to that survey, that there were no great crested newts at that date, didn't it?
I think I've answered that before. It shows there weren't any newts in those ponds which they surveyed, but they didn't survey other ponds.
Yeah, but it made the point, but it was unlikely for the
Mr.
reason.
Masters, I've heard what I need on this
You've
point.
got the
Move on,
point.
please.
I'll move on, sir.
And I'll
Okay.
also warn you about your time limit. You've got 10 minutes on your upper time limit.
I may be longer, so because I'm not
Well,
getting much cooperation from Mr. Hibbert, and I will insist on taking as long as I need to. But I'll try and
you can't
be
take as
quickly.
long as you need.
No, I won't. But I'll take as long as
I would encourage you to give
I will, sir.
questions that are shorter and not to repeat yourself.
I understand, sir. I understand. So, Mr. Hibbert, there is absolutely no evidence of badgers. We've had a walkthrough survey. You criticised the walkthrough survey, but that didn't find any badgers, did it? Did it?
No, it didn't find badgers. It found mammal paths of unknown origin, but it didn't find badgers.
Thank you. So no evidence of badgers, no evidence of great crested newts, and absolutely no evidence of littlewood butterflies. All we have is flowers and habitats that they might find useful. That's the extent of the evidence.
I agree they didn't find wood-white butterfly because no surveys were carried out for that species.
So let's read the note in the PPG again. As with other supporting information, local planners should require ecological surveys only where clearly justified. There is no evidence here at all of any protected species that would justify further surveys because despite what you say, and the assessment should be proportionate to the issues and scale of them proposed and the likely impact on biodiversity. Now, no one is talking about damage to protected species because there isn't any. No one is talking about damage to the habitat of protected species because there isn't a habitat, because they're not there. So please tell me how it is that the inspector shouldn't interpret that section as being that what's been done is sufficient.
I don't think I've got much to add to what I previously said, Inspector, in the long list of species and the important habitats. I mean, it would have been proportional to do proper surveys prior to the development being implemented.
I've no further questions, sir.
Thank you, Mr. Masters. So that there's only one thing I think I want to put to you. That's in connection with the point you've made about the loss of habitat and its implications, and just be interested in your view, given where we are with the appeals, how that situation could be resolved.
Okay. If the appeals were dismissed,
Yes.
and the hard standing was therefore removed from the site, then vegetation would naturally recolonize and provide some habitat suitable for at least some of the protected species. To ensure the replacement of the woodland, I think tree planting would probably be needed. Otherwise, the land would revert back to a grassland moderately similar to the grassland that was there before the development. And of course, the watercourse would need to be dug to its previous state.
So natural recolonisation would depend on removal of the hard standing.
Yes, it would, sir. Yeah.
And alterations concerning the watercourse.
Yes, sir.
And how would that occur just as a consequence of dismissing the appeal?
I'm not sure I've got an answer, except it's possibly for the planning consultants to discuss on the implications for the dismissal and how it affects the site. I mean, if the appeal was dismissed but the hardcore was left, I'm sure it would eventually vegetate over, but I also suspect it would be a weed-dominated vegetation dissimilar to what was there before.
Yeah. Could there be a benefit from a conditional planning permission? Could that achieve some benefit in terms of nature conservation and biodiversity?
I think because the whole of each appeal site was natural habitat, a condition to allow the creation of a small part of each of those sites as natural habitat would be far too small to be worthwhile.
Okay, thanks, Mr. Sibbons. Mr. Lintos, I don't know whether you've got much in the way of re-examination. I'm just wondering whether to take the afternoon break now, or
Yeah, that might be a good idea. I've got a couple of points, and if you give me 10 minutes, I'll put them into a quicker order to go through, I think.
that would be helpful. Yeah. We'll take 10 minutes now. Adjourn the inquiries adjourned. We'll resume at 3:15, please. Thanks. Sorry, there are very strict rules about, yeah. It's okay. Right, let's resume the inquiry. Mr Lintott,
Thank you, Inspector.
Examination of Mr Sibbett.
Just 3 points, Inspector. So the first coming out of your question, Inspector, really. So first point for you then, Mr Sibbett. If planning permission is dismissed and the council takes enforcement action against the use and associated operational development, including hard standing and any material in the watercourse, as they have done in respect of sites C and D, what would be the case in respect of the trees? Because there's woodland all around, and I'd just like you to help me with, and help the inspector with, would woodland regenerate or not, given the presence of woodland around it?
I think when hard standing was removed, it would expose the soil beneath. So there's a possibility that there may be tree seed in the soil which will regenerate, but it may need tree planting to ensure that woodland does regenerate in its former location.
And if so it may or may not, and if not, you would have what happening in terms of habitat on that site, and would that be valuable?
So I would expect the grassland which was there to regenerate from seed in the seed bank, but if it doesn't, I would expect seed from the adjacent grassland to move in. So it could blow in, for example, or it could be carried by ants or invertebrates or by mammals externally or internally. So I'd expect the grassland would regenerate over time.
So the second point is in respect of the statement of case. So Melinda Friend put you the reason for refusal. You have put together part of the council statement of case in CD 4A.4 through to CD 4A.7. And in respect of those elements in the statement of case, how do you, if you do, rely upon those as being the relevant matters for the inspector to decide upon?
In my statement of case, I relied on the appellant's documents for information, but because they didn't mention the watercourse, the appellant's ecology reports, such as that Arctic report, at that time I hadn't realised the watercourse was lost.
And finally, Inspector, in terms of one of the points put by Mr. Cottle, I believe, in respect of bird's foot trefoil and meadow vetchling, which you explained to him were the food plant, the caterpillars, and the plant upon which the wood white butterfly laid their eggs. The suggestion was put based upon one of the photos that they were common plants and you could find them in most grassland or the potential for them. What would you have a comment on that? Would you agree that they're common plants, and what's the status of unimproved grassland in the UK these days?
Those plants aren't rare on a national scale. Unimproved species rich grasslands are at a small fraction of their previous extent. Many have been lost over decades. But I think there must be something in the ecology of wood white that, although it's got its southeast main population in this area of the appeal case, it doesn't seem to use those plants in a more widespread way. So I'm not quite sure what that is. If it was simple that every meadow vetchling and every bird's foot trefoil could be used by wood white, it would be a common species.
And related to that, do you remember that Maloney friend Mr. Cottle put to you the situation in respect of the land to the south of the access track, and he said, well, there's been permission granted in respect to this area of land. And you said that, well, you felt that you didn't know because you hadn't been instructed in respect of that matter, but you gave a series of points, and one of them was the grassland may not be the same type of grassland. And again, could you help help the inspector understand that, the difference between different grasslands and why it might be that the grassland would be different to the south of the access track rather than unimproved grassland to the north?
Yes, maybe to help that, we could look at one of the aerial photos of the grassland north and south. So, we can get the ARBTEC report, CD 2A.6, I think, but for aerial photos previously. Page 16 of that report, sir.
This one with the two small
With the two small Google Earths, yes. I'm sure there are other Google Earth images available, but on figure 10, for example, north of the track, if you look closely, the grassland looks a bit textured. So there's a range of heights and a bit of scrub in there, and that shows it hasn't been managed for some time. But south of the track, generally, it looks a bit much more uniform, although some parts perhaps a bit being worn from trampling or grazing or something. So that's why I think the grasslands are different. And yeah. The green colour looks a lot more textured to me. On the south side, it seems a lot more uniform within each field, although with bare patches where it's possibly trampled or grazed heavily. So that difference makes me think that south of the track doesn't have that species richness and the long grass and the scrub mosaic, which the wood white butterfly requires, and the other protected species would benefit from. For example, for sheltering in long grass, doesn't appear to be there south of the track.
Yep, that's all the questions I have. Thank you, Inspector.
Thank you. Thank you, Mr. Sibbott.
Thank you.
And we'll move back now to Mr. Woods again. And given that we've completed with Mr. Sibbott's, perhaps we can now have in a moment or two when Mr. Sibbott's moved, have the questions from the parish councils. Can I just check whether, I think I said Councillor O'Sullivan, is it Councillor Sullivan? Yeah, sorry for getting that wrong. Councillor Sullivan, do you want to come down to the main body of the chair so that you can sit near a microphone somewhere? Well, perhaps not in the sense, if you could just find somewhere, a seat on the council side where there's a microphone. That's, as I understand it, councillor, you're from Hascombe Parish Council, but the parish councils are cooperating on this case.
Yes, sir, I
Yeah.
am from Hascombe Parish Council. I'm the chairman.
Right,
I'm
thanks.
possibly a little nervous. Sorry.
Right, so opportunity to put the questions that the parishes have on flood risk to Mr Woods, and I'm sure he'll do his best to answer them.
3 little questions, Mr Woods. First one,
Good afternoon.
if the drainage ditch is to be reinstated and the water runoff from the soakaways goes into this ditch, as you were explaining earlier, it could be in an acro culvert. How do you propose to deal with the sewage?
Well, this is a bit confusing really, because I'm
Yeah,
talking about
that's-
surface water drainage.
I know, yes. There's two types of drainage, councillor. Surface water, which is what we've been talking about so far, and obviously you've taken a slightly different view. Can you assist Mr Woods? I know it's not part within the scope of the flood risk
Yeah.
issue.
Certainly. So in terms of the surface water drainage, there's two ways of dealing with that normally on site. Well, normally you would have a soak away, or it will go into the main drainage. Because of this site, because the ditch will be reinstated, there's the opportunity for the surface water to go into the ditch, and it will be acro drains. So you'd have drains running into that area. So the water goes into the drain like a French drain, basically, and then will go into the ditch and get dealt with in the normal way. In terms of foul drainage, there's not been any issue raised about that, but I would imagine it will be by way of either a packaged sewage treatment plant, or running down to a cesspit if that didn't work for whatever reason. First of all, we looked to see if you could connect to the main drainage. I don't think there'd be any opportunity to do that because of the distance involved. And so you look at it in a hierarchical way. So first of all, you look at can you connect to the main drainage? Yes or no? Why can't you connect to the main drainage? So you'd explain that in any submission. And then you look at the next thing would be a packaged sewage treatment plant. And that may not be appropriate because of land that's available. And then you go down to the lowest common denominator, which would be the cesspit, which I would imagine most of the other sites on Lydia Park are dealt with. And so the sewage will be collected. And on the cesspit system, typically what happens is there's an alarm when it gets to a certain level. So there's plenty of tolerance for them to be emptied. And the lorry would come along and take the sewage away. So that will be the way forward. And in terms of drainage, I would imagine in the conditions that put forward by the council, I can't remember offhand, but there will be something about foul drainage, and it will be up to the individual appellants to submit their details to the council. I had it on one case where we said we would only have a cesspit if it was a temporary permission, and we then made the submission to the council, but because the site sloped up to the main sewer, the cost was excessive. So we said we came to the solution that we couldn't have a pumping station because of the nature of the occupants, because they travel away from the site. So if something went wrong with the pumping and the sewage came out, that would be a problem. So it had to be a cesspit. So we submitted that to the council. The council refused that, and we went to appeal in respect of that. And the inspector allowed the appeal because it was the only solution relating to the site. Long answer, but I hope that answers your question.
That was fantastic. Thank you. My second question, if the statement made earlier today in respect of the tree clearance, you said could have been scrub, referring to where there were trees. Where do you base this evidence when the aerial photographs submitted for these 4 appeals show trees and their removal in 2021-22, along with the addition of the hard standing. And we have submitted proof. Proof is of intentional destruction would be, I've written it down here, April to June 2021 with no felling license. The trees were over the diameter and the quantity. So where do you find your proof when we've submitted it in our documentation?
Councillor Sullivan, I'm going to intervene because in terms of what was on the site, and there's been a lot of discussion about that. Your questions on that can come later. It's really outside the scope of the drainage topic that I invited you to come back on. So it's not, that one's not really for now, because Mr. Woods hasn't given us evidence on this yet.
Happy to answer it, but it's not for.
No, I'd rather do it in the in the usual order, Mr. Woods. So I'm not forgetting it, Councillor Sullivan, but can you just hold fire on that point, please?
So my third tiny question about the drainage ditch. So maybe it's reinstated.
Sorry, maybe it's been.
Maybe we reinstate it.
Right.
How can, under conditions, this be enforced?
Well, there'd be a condition that we put forward. It's suggested condition option 3 that will go on to, which we put to the council on the 6th of June last year. It can go on the council's website as part of the suggested conditions, and that is details of that to come forward. And of course, the Drainage Authority have rights to action things like that outside of land that's controlled by any of the appellants. So it's and it will be the way the condition will be worded that you have to submit those details and they have to be done effectively, otherwise the permission will fall.
Okay, thank you.
Okay, sir.
There is a problem that I've been made aware of more. Yeah, I'm well with the work around it. It's Matthew off, isn't it? Well, yeah, Margaret, obviously, son's in school races. It started out after lunch. I would have thought with the system job that wouldn't be an issue. Well, I think I'm racing, so he wouldn't be here in the morning.
Sorry, he wouldn't be here in the morning.
He wouldn't be here in the morning. He'd be here at lunch. At 1 o'clock.
Right, at the moment he's down for the afternoon. So.
Yeah, so that would be okay, but I wanted to explain that.
This is Mark Doherty in the afternoon.
Yes. He would be here for the afternoon, there's no doubt.
Well, if we got through things more quickly, presumably we could bring Matthew Doherty up first.
Yes.
Yeah.
Thank you, sir.
Okay. Right, it's Mr. Woods then, in terms of the ecology issue. Given that I've been wrong-footed already on who's going to start,
I'm going to start.
You're going to start, Mr. Cottle. Okay.
So, good afternoon, Mr. Woods. If I can invite your attention, please, to your proof from October 2024 and to page 43 through to 45, which deals with, page 44 to 46, which deals with the effect of the proposal on protected species, main issue 3, paragraph 914. Now, if I could direct your attention to paragraph 916 or 915 and 916. And 915 says further survey work was undertaken which confirmed appeal site A would have no impact on greater crested newts. I can take that as reading that across to PLB. But the point that's made against us is that Thatched House Farm has a pond that wasn't identified by Darwin or Arbtech, and that the greater crested newts in the pond at Thatched House Farm would have used the land as a habitat. And if you develop the habitat, you cause loss of the habitat. Therefore, you're in conflict with the policy. That's the argument against us.
I understand you.
And I just want to refer you to the Thatched House Farm decision, which is, I've got it as an inquiry document 16, which went in November 2024. And I took Mr. Sibbott to it earlier this afternoon. And it's the decision which granted planning permission, and it's an officer's report that sets out the thinking behind the approval.
Corridor 16, wasn't it? Yes, yeah.
And it's at page, I've got it as electronic page 17 of that. Is it 17 or 16? Well, I'm just reading the electronic, sorry, okay, that's the way we had the problem last time. Well, it's the same paragraph I'm taking this witness to as I took Mr. Sibbott to. And it's the one that's on ecology and biodiversity. That's right, yeah.
So it's on page 17, do you say? So
Well, it's
16 or 17?
18, it's a bit
18.
further down. It comes under climate change and crime and disorder and stuff, but it's got biodiversity and compliance with habitat species regulations. So you're looking at 17 and it's just a bit below that, 18.
18, yes.
Good. It begins the NPPF requires, etc.
Yes.
And it goes on about habitat survey and reptile presence and so on, and also precautionary method statement regarding greater crested newts. And then it says at the bottom, overall, it's been demonstrated that the proposal would not cause harm to protected species. So the question is this: we're being told that we're interfering with the habitat of greater crested newts. Yeah?
Yes.
We're being told, therefore, we're in breach of policy. Yeah? Is there any, well, what would you say to the inspectors as to what weight to give the fact that where the greater crested newts are coming from satisfactorily, the concerns over their welfare satisfactorily addressed at Thatched House Farm? Is that a material consideration?
Most certainly is, yes. It's dealt with. That's where they're actually coming from, as to where they might be going to for foraging.
Just for the inspector's record, I put it to Mr. Sibbott that one of these things about lack of prior survey or interference with habitat still needs a balancing exercise to be carried out. But
Yes.
when the inspector embarks on that balancing exercise, does he take an accepted premise that we do accept that we're causing loss of greater crested newt habitat, or does what's your position on that?
No. There's no evidence as such relation to that. So no.
Sorry, Mr. Woods, I missed part of your reply. Could you just give it again, please?
Yeah. So I said that no, I don't believe habitat has been destroyed. But even if I'm wrong, then there could be an enhancement to habitat by way of a planning condition, which won't be achieved otherwise.
Which brings us to the mitigation strategy in relation to greater crested newts
Yes.
and the steps. That's again another inquiry document now. that was, I think it's got Peter Brownjohn's name on it, that's attached to the decision letter that we handed up this morning from Inspector MacDonald, if I believe,
Okay.
regarding the Buckingham decision.
Ah, yes, yes.
Do you have a copy of the Buckingham
Buckingham
decision?
decision? Yes, I do.
And do you have a copy? Can we get to the ArbTech mitigation report at the same time?
Yes, if you can tell me, I think it goes with all of them, doesn't it? So it doesn't matter which one I go to.
It was an earlier ID number.
Oh, right, okay.
Do you have it, sir?
Yes.
Sorry.
This is ID 7.5.
That's right. And what this does is it talks about the various steps that can be employed in relation to greater crested newts.
Yes.
So if the inspector finds that the granting of permission will actually cause a loss of areas of scrub grassland that were previously used by greater crested newts emanating from Thatched House Farm, what weight should be attached to the possibility of steps like these that we're proposing? You've got a condition set out in your proof at 921.
Yes, indeed. The situation relating to Lawn Hill, you will see Peter Brownjohn's name on the ArbTech report. It's because we submitted the planning application relating to that site, and I visited the site before any work was undertaken by the appellants. The application was refused, and we didn't deal with the appeal. We were disinstructed. But the benefit of this is that I know the site. And so the solution is what we're proposing for the current appeal site, which has been found to be acceptable by an inspector.
If it can be done for Thatched House Farm, why can't it be done here?
Well, exactly right, yeah. No reason whatsoever.
And you said you've got some personal knowledge because Mr. Sibbott was trying to distinguish the Lawn Hill, I think it is, decision. Have you got any comments on that?
Yes, I think Inspector MacDonald, she refers to file standing, I believe. Yeah, paragraph 37. This is the Buckinghamshire decision, Lawn Hill, inquiry document 18. The particulars of this case, paragraph 36, was there was actually a pond in the adjoining piece of land. So there was the site, the appeal site or the application site, and there was a hedgerow. There was a public right of way that ran past the appeal site, just the other side of the hedgerow, and past a pond, which was just the other side of the hedge. So it was right next to the appeal site. So that was the first point. Secondly, the inspector said that there were significant works already undertaken in the form of hard standing. The proposed works would create a new access. When I visited the site, there was some debris on the site. It wasn't hard standing as such, but there was, whether it had been fly tipping or whatever, there was some rubble on the site. Nothing to do with the applicants and subsequently the appellants. So it was work that had been previously undertaken. So it wasn't all undertaken in relation to the planning appeal that was being considered by the inspector.
Is the inspector to somehow attach less weight to the possibility of doing a condition in that form because of what Mr. Sibbott said? Sorry, is the inspector somehow justified in giving less weight to the possibility of a condition because of what Mr. Sibbott said?
No, I don't believe so. That was a case where the ponds relating to the newts were right next to the site, so wouldn't take them very long to come across the site, and the inspector found that it was perfectly in order for a condition to be imposed, like we're suggesting in the current appeal site.
On a different topic now, if I could take you to the statement of case CB 3.1, please, which is the local planning authority's statement of case. CB 3.1, 3B, and it's a paragraph 316, page 6 of that document.
CD 3B. 1. Okay.
Yes.
Yep. Thank you.
Now, what we've established today, I think, with Mr. Sibbott, is that he doesn't know that the woodland white butterfly was using it. He's saying that if the white woodland butterfly used it, it would have found some plants that it likes to dwell on. And we know that the next door adjacent place is a part of a project for encouraging wood white distribution
Yes.
or wider distribution. And what was said in paragraph 319 is that because of the possibility of there being white woodland butterfly, it's not unreasonable to require that its presence or otherwise is ascertained prior to any grant of permission. And of course, it was, I think, a retrospective application in any event. But from the thatched house farm permission and from the evidence that we've got in this case, do you still feel that the failure to look into the woodland white butterfly is a reason for this appeal being dismissed?
No, I do not, because it's the adjoining land where that encouragement is to take place. There could be encouragement on the appeal side and appeal side B for planting of species that will be welcoming to the wood butterfly, wood white butterfly. So I don't see that as a reason. And I draw from it relating to the Surrey Wildlife Trust response on the applications, where they actually set out the various mitigation, what should be done. They don't object to the applications. I think that's quite telling, because it's unusual, I have to say.
If there can be the planting around the perimeters, would it fail because of being in the shade, as Mr. Sibbott suggests? Can that be organised to avoid it?
Yeah, I mean, in the shade of what? I mean, the site is not in shade. Depends what part of the site you were. But I suppose if you were at the hedgerow that adjoined the wider landscape, at that point there, you got a mobile home in front of it, so some of it would be in shade, but the majority wouldn't, and down the side planting wouldn't, and the planting, no, I don't accept that.
If there was an interior corridor inside of the boundary, would there be enough space still for the mobile homes and the corridor of planting?
Yes, I mean, that was shown on the indicative landscaping plan that was produced by Petra Harley relating to the appeal site, and it showed the hedgerow, it showed the planting, it showed where the mobile homes could go, showed the circulation space. It did show an area of parking at the front of the site, which is not essential because each individual area has its own car parking. So,
and are you in a position just to tidy up the loose end that the inspector raised this morning about the extent of the location of the site as to what the distance is? Because Darwin is said to have got the wrong measurements. Do you understand the point?
I do understand the point.
It's in Mr. Ward's proof most succinctly.
I do understand the point, but I haven't got downloaded plans to measure. It's something I can request and find out. It's shown at CD1B6 as the block plan. It is a scalable plan at A3, so I can make arrangements for someone in the office to print it out, well, and measure it up and come up with a distance.
The relevance is how many square meters of this planting you get. Depends on the size of the site. So that's why I was asking.
Okay, yeah. So we can do that in terms of the hedgerow and the planting space that will be adjoining the hedgerow. Well,
I may have misheard Mr. Sibbott because I don't think he was owning what I was attributing him with, but I thought he was saying that there would be something over 300 square meters of possible perimeter.
Yes, you did say that, and he couldn't recall whether he said that. But I can measure it. We can measure it up, and we can provide the information to the inquiry on a factual basis.
And is that a reason to count against allowing the appeal?
Is that a reason for?
Is the interference of the white woodland butterfly sufficient reason to count against granting this appeal?
No, there's no evidence of the white butterfly being on the appeal site.
But if there's some compensatory or mitigation measures to have some planting there,
yeah, even
if there was,
yeah, well, even if there was, then you'd have some planting that would mitigate that potential harm. But if there wasn't, you would actually provide more suitable space for the wood white butterfly.
Now, looking at the document that we were just looking at before, which was the local authorities statement of case, what it went on to say is that as this is a protected species, it's not considered unreasonable to require that its presence or otherwise is ascertained. And then it's not possible to conclude that the impact of the proposed development to protect species would be acceptable. And then there's reference to policy NE1 in the statement of case. But today we've heard about policy NE2 from Mr. Sibbott. And I stand corrected. The local planning authority's evidence through Mr. Sibbott has always been in relation to NE2, I think. And what's being said is that we conflict with the requirement in policy NE2 that wants to retain or create an undeveloped buffer zone to all watercourses of 8 meters from main rivers and 5 meters from ordinary watercourses. And then there's a footnote down to the Water Framework Directive, which establishes a legal framework for the water management of coastal waters and all inland coastal waters to achieve good status. And it goes on about rivers, and Waverley be divided into river basins, and there's a lot about rivers there. Now, putting to one side whether this is a watercourse for the purposes of the policy, can we comply, or do we conflict with the requirement of having a buffer zone of 5 metres?
We can comply with that. At the front of the site, there can be a buffer zone of 5 metres without any particular problem to the site. I would raise the point that obviously in reason of refusal, you're supposed to be precise, knowing what you're coming up against, and NE2 doesn't feature in the reason for refusal.
Well, it's in the statement of case as well.
Yes, yes it is, but it's not in the reason for refusal. But anyway, that by the way, it doesn't matter, because we can achieve that. We can achieve a 5 metre strip.
Well, Mark Doherty is a long way away from that, and so is Matthew. But what about Thomas?
Yes, you could achieve that. Yes, we're moving things around. You can achieve it on the sites that I'm dealing with.
And have you got anything to add on the baseline? Do you know of decisions where people have bought land where woodland has been previously chopped down, and they're told that they can't develop because their development causes loss of habitat, which is already gone?
I can't recall a case where that has occurred. Sometimes there has been a change in habitat, but it's been in the ownership of the applicant that I meet. So I see an applicant, I see something on the site, and then when we check back, it's completely different. Now, if they've done that, well, they've done that. But if somebody else has done it, they can't be held responsible for somebody else's actions. Can't be right.
I was putting it to Mr. Sibbott, you go back 10 years, 15 years. I think Mr. Sibbott would say that it's always relevant to look at the history.
Well, it's maybe relevant to look at the history, but it shouldn't be determinative if it was something that someone nothing to do with the applicant or appellant has done something with the land, and the applicant or appellant has bought something, and it is what it is at that stage.
Is that a proper basis for the inspector to go forward?
Not from what Mr. Sibbott said. No, it's not.
But from our point of view, it is what it is. So they bought it after the woodland had gone, from Mr. Doherty's point of view.
That's right. It wasn't there, so it would be, I think, unfair to hold it against the appellant when it's nothing to do with the appellant.
Would you want to say something about the significance of the harm Mr. Sibbott is attributing to the loss of the habitat if woodland is taken out of the equation?
Well, we're proposing in our illustrative plan additional tree planting as well as hedgerow planting and the biodiversity strip.
Do you agree with him that significant harm?
No. Has been some harm, not significant.
Sorry, Mr. Wood, did you say some harm?
Some harm, so yes.
Yeah, thank you.
And if there's going to be the meeting of the pitch targets in rural situations, greenfield situations, will there be harm in those situations?
Yes, I mean, it's inevitable that there will be some harm in all such applications to meet the need, but you can't have any form of development without some form of harm.
I've got no further questions.
Thank you, Mr. Cottle. Mr. Masters? Thank you very much.
Mr. Woods. Mr. Woods, we took Mr. Sibbott to the reason for refusal 3.
What, sorry?
I took Mr. Sibbott to reason
Yes.
for refusal 3, which deals with protected species. Does that deal with the other issues that he raised?
No, it does not.
In terms of protected species, what's your view as to whether or not on this site there is presence of newts, bats, badgers, and the white wood butterfly?
There's no evidence of any of those.
I took Mr. Sibbott to the PPG. Do you have a copy in front of you?
Have a coffee?
Yes, I did, sir.
Yes, I've got that. Yep.
And Mr. Sibbott quoted from the first paragraph that any ecological survey will be necessary in advance of planning applications if the type and location of development could have a significant impact on biodiversity and existing information is lacking or inadequate. I'll just pause there. We know that ecological surveys were carried out.
Yes,
Do you say that they adequately and properly addressed the baseline at that time?
yes, I do.
What do you say to the fact that Mr. Sibbott is saying, oh, no, you've got to take the baseline as an event that occurred in 2000 and I'm just reminding myself the date that the 2021 April to June is what the parish council has just said, that the all the trees were felled and the landscape and the hard standing occurred. Was that anything to do
Well,
with?
There's nothing to do with the appellant, so it shouldn't be brought to bear on them.
Thank you. I mean, if we go back to the PPG, it says in the last paragraph, as with other supporting information, local planning authorities should require ecological surveys only where clearly justified. Just pause there for a moment. Mr. Sibbott's proposition is no reports, refuse planning permission. Do you agree with that?
Well, there were reports, so I can't possibly agree with that because there were reports that were submitted. And it's up to the local planning authority to require whatever reports are necessary to validate a planning application. The planning applications were validated and determined.
And he goes on to say assessment should be proportionate to the nature and scale of development proposed and the likely impact on biodiversity. What is your view of the likely impact on these cases on protected species? And let me just pause there again, if I may, because a point was made by Mr. Sibbott that might have been lost. The term in reason for refusal 3 is protected species, isn't it?
Yes.
And we've already heard that the white wood moth is not a protected species, is it? Under European regulations. Mr. Sibbott made that point.
I think he did, yeah.
But even if the inspector interpreted protected species to include this particular moth, although it's not protected under that legislation, and we've already said it doesn't, it's not on site, would it be proportionate, therefore, bearing in mind the likely impact on the white wood moth will not be high because it's not there, for this site to be refused?
No, it would not be proportionate.
Is there anything else you want to add?
No.
Thank you.
Thank you, Mr. Masters. Mr. Linsop, please, when you're...
Thanks, Inspector. So, Mr. Woods, in respect of the difference between yourself and Mr. Sibbett, insofar as the inspector is concerned, you're both agreed that there's been some harm caused by what's gone on. The question is the degree of harm, isn't it? That's what you've just said,
Yes.
Chief. And obviously, to a degree, that is a matter of judgment
Yes.
and relevant.
Based on the evidence that's available.
And relevant to judgment, where one's dealing with ecological harm, is one's experience and qualifications in ecological field, isn't it? That's relevant.
Yes.
And
But we
so-
had, in this case, we have two assessments that were carried out by ecologists, and I rely upon those. I'm not an
take those.
ecologist.
Yeah, but those ecologists haven't given evidence, obviously, at this inquiry.
Sorry, those ecologists?
Haven't given evidence at the inquiry.
No, it's a matter of fact, no.
And in terms of where we can see the elements that together make up the harm, can I ask you to have a look at the report that's been put in respect of Site A first, CD 2A.6.
CD2A.
Yeah.
Hmm. Some reason it goes from CD1B12 to CD2B1.
Well, if you go into 2A, so the appeal A, so close down B.
Oh, appeal A.
Yeah, go into A.
CD2A, yes,
And it's 0.6.
okay.
And when you've got that, you should see the Arbtech PEA for Site A.
Yep,
And we can see there, if you turn within that document to page 16, and I think the PDF pages are the same as the physical pages, Inspector.
okay.
We can see a table there which begins with habitats and then goes on to deal with species. So you can see on page 16, do you see there's a box there which is talking about the woodland that's been removed from Site A? The top
It
box.
says, yeah, the Google imagery from 2018 to 2021 shows the site appears to have previously been broadleaf semi-nature woodland.
Yeah. And in respect of, if you read on, you can see that it describes it as being deciduous woodland habitat of principal importance under section 41 of the NERC Act 2006.
Yes, see that.
So, and you don't take issue with that as a description of the woodland, do you?
No, if that's correct, yeah.
And in terms of how that sounds in policy, do you recall that when Mr. Sibbett gave evidence, he explained that in terms of policy NE1 and in terms of his figure 1, that this was important because it came within B3 of that policy. Do you recall the evidence that he gave to that extent?
I do recall that, yeah.
And again, you don't suggest that he's wrong in respect of that, do you, in terms of the facts as to whether it comes within that part of the policy?
No, the point is that any works relating to that were nothing to do with the appellants.
Well, I'm not going to suggest to you that they were the appellants, but they
Good.
plainly were part of the development, because they're part of the description of the development is to provide the hard standing, isn't it?
But it doesn't say and remove trees.
No, but that's a consequence of putting the hard standing down, isn't it?
Well, sorry, the consequence of putting the hard standing down is that the trees are removed. That's what you're saying.
You couldn't
putting
put the
to
hard
me, is it?
standing down without removing the trees first.
No, but if it's nothing to do with the appellant, it's not not an issue that should be levelled against them.
And in respect of the other elements that one sees if one goes down, I don't see you as disagreeing with what Mr. Sibbett has said in respect of the various species. So in respect of amphibians, for example, do you recall in his evidence that he read out the last bit and said, that currently with the site in its current state, it's got negligible value, but they may have been present originally. And then reptiles, he read out the section at the bottom saying that that their habitat has been removed, so it's currently negligible, but it may have provided reptile habitat. And he went through in respect of bats and badgers and birds and invertebrates on those pages. Do you remember that section?
I do remember that.
Yeah.
And yes, as I said, some harm has occurred to habitat, I suppose, but there's no evidence relating to harm to badgers as such, no evidence of harm to bats or great crested newts. So there's no evidence relating to that. So it shouldn't be levelled against the appellant. And what we're proposing is to enhance the biodiversity, which will be enhancement with the help of those species. And for example, if there are trees, then there are trees relating to Appeal B, but there are around Appeal A, then typically there'll be a requirement for bat boxes and a lighting strategy. And the lighting strategy that we submit all the time for planning applications would typically be a pillar light, low lighting, with a light going down to the ground, so it's not interfering with the bats' foraging area if there are bats in the area.
So there are essentially two elements of harm that Mr. Sibbett spoke to. There's obviously the harm that's caused by developing across the appeal sites A, B, C and D and replacing that habitat with the structure of the development. And so that's something which has happened, and you're describing ways in which you could try and compensate for that, aren't you, in what you've just said?
I am, yes, and that is the appropriate way forward. As I said, evidence in chief, any development, whether it's a gypsy traveller site or housing or whatever, is going to cause some harm. And what we should be doing is as planners, is saying how we can mitigate that harm and provide some enhancements that will be good.
So one thing that one needs to look at is the specifics of the site, isn't it? Because of course you might have a scenario where one particular site, there's a particularly high degree of harm, and in which case it wouldn't be appropriate to develop that site. Whereas another site, there may be a lower degree of harm, and it might be appropriate to, when one takes the balance into account, to develop that site. So I don't see you're saying that in respect of just because there will always be a degree of harm, that means you always develop sites. It's a balancing act for the inspector, taking into account the degree of harm, isn't it?
Well, it depends on the circumstances in each case, of course. But what I'm saying is I've accepted there's some harm, and so any site will result in some harm.
And it's for the
because
inspector.
the site's not going to be in the middle of Hazelmere, for example, or Cranley.
And really, it's for the inspector to look at this site and to form a view as to whose view he prefers as to the degree of harm, because that obviously feeds into the planning balance.
Sorry to interrupt,
it?
sir, but isn't the difference between the parties, the degree of harm stems from what baseline you take?
Well, I mean, that's a submission. It's certainly not appropriate to say that during cross-examination.
Isn't that the difference? I'm trying to crystallise matters.
Now's not the time to do this, Mr. Cottle. I'm interested in the question, the exchange with Mr. Woods.
And in terms of how one goes about addressing harm, you look at the ways in which elements of harm can be compensated. But if you have a look at page 7 of Mr. Sibbitt's proof of evidence, where he introduces the policy framework for biodiversity in the borough. So can I just ask you to turn up his proof of evidence is at CD 8A.3. Mr. Sibbitt's at CD 8A.3.
Okay.
And if we look on page 7 there, do you see policy NE1, which Mr. Sibbitt discussed in his evidence?
I've got a copy, but it's not.
I'll get there. It's just I was at the other end of the document for some reason.
That's all right,
But
don't worry.
page 8, is it?
Well, it's page 7, actually.
Page 7.
Yeah.
Okay.
And in respect of the policy requirements, in terms of little a and little b, so in respect of the elements of the appeal sites that have been lost through development, well, obviously you couldn't say that the biodiversity has been retained, protected or enhanced in respect to little a. So there's been a breach of little a. It just depends how significant the breach is, hasn't there? And that's where the harm derives.
Yes, in relation to biodiversity, but that wasn't a reason for refusal. But yes, I will accept that. In terms of retrospective applications, they're exempt from biodiversity net gain.
Yes, and I'm not asking you about that. I'm just talking about biodiversity as you properly confined your answer. And in respect of B, ensure any adverse impacts are avoided or unavoidable are appropriately mitigated. As a matter of fact, it doesn't contemplate compensation within the confines of NE1. It talks about mitigation, doesn't it? And you don't propose mitigation because the habitat has been removed. You propose providing elements of compensation for it.
Well, I think it is mitigation.
Well, so in terms of how you see mitigation, if you remove something from a site, whether it be biodiversity or anything else, and you replace it with something to compensate for it, do you understand that to be mitigation?
Well, policy says ensure any adverse impacts are avoided, or if unavoidable, appropriately mitigated.
So my question is, if you have, let's say, to make it this case, if you have a woodland covering a site, and you fell that woodland and cover it in hard standing, but you propose to provide some form of compensation to replace for the biodiversity value, do you understand that to be mitigation? Or do you recognise that that's compensation which is distinct from mitigation?
Well, we don't accept that the appellants have taken down trees relating to the site. So I can't accept that.
No.
If someone else did that, it shouldn't be levelled against the appellants. And you can, if there's an adverse impact, it says you can mitigate against it.
What's the difference, Mr. Woods, between mitigation and compensation?
Mitigation is balancing something up. Compensation would normally be the same as what you're taking away.
And when you're balancing something up, I would suggest to you that requires you to leave something to balance. So if you've removed something, you can't balance it. You can only compensate for
You
it.
keep saying this. The appellants haven't removed things from the site.
But that's not the premise of the question. I'm asking you about what you understand to be, I mean, don't think about the specifics of this case at all. Just think about a completely neutral case where somebody's removed something and then they put something to compensate. So that's what I'm asking. I'm
Somebody
asking you your
who?
understanding.
Somebody who? Not the
Anybody.
appellants. I
Anybody.
can't comment on something like that.
So haven't
If
we
if
been-
it was the
haven't we been-
appellants that removed it, or on another side, the applicant or the appellant removed it, and that's the case, then yes, of course.
So
But
haven't,
it's not the case.
hasn't this question been asked several times and
Well,
Mr Wood's making the same answer each time?
Well, Inspector, what I will ask, I'll carefully ask the question, and then if Mr Woods says that the appellants haven't done it again, I'll just move on.
Move on, yes, please.
So the question is, if mitigation involves balancing something up, if hypothetically one removes something, how does one balance it up?
Well, you look at what has been removed and you look at what is being proposed. And what is being proposed might qualitatively be better than something that's in a quantitative way. So just because something is less doesn't mean to say that it's not better. It could be qualitatively better.
So moving on to the next part of the policy, NE1 then, we've looked at NE1B and we've got little 3 and you've agreed with me in respect of what that contains. But then we see at the bottom of that, Mr. Sibbett has put it in bold, he's put that part of the policy which says how one treats priority habitats given the designation. And he says that within locally designated sites, development will not be permitted unless it is necessary for appropriate on-site management measures or can demonstrate no adverse impact to the integrity of the nature conservation interest. So in terms of the requirements that one puts there, you don't suggest that those are present in respect of this particular case, do you?
Well, there's been no locally designated area that's been changed.
So
Are you talking to the I'm asking you a question. Okay, I should be doing that.
that's all right.
But just to understand, to where the corridor for improvements for the wood white butterfly was a 3 kilometre area. That's off-site. So is that the area you're talking about, the local designation?
So what I'm talking about really is the, you recall we looked at the NERC Act defined deciduous woodland that had been defined as being a priority habitat.
Oh, right,
So it's
yes.
in respect of that element. And really what the policy, Mr. Woods, is looking at is, well, sometimes you might need to have development in order, if you've got something which is a locally designated site to manage it. And in those circumstances, it wouldn't bring into play the auspices of the policy because you might have to have some development to manage the site. So it's contemplating those sorts of interests. And really just for completeness, I'm just suggesting to you that, well, it's obviously not suggested that that part of the policy is in play.
Well, that goes back to the point of what was there before. And we don't know for certain. Yeah. And if there was something there before that fell within that definition, it wasn't the appellant that took out those trees.
But again, I'll just ask you just one more time in relation to the specific words after permitted, the unless it's necessary for appropriate on-site management measures. Those words, you're not suggesting, if the rest of the policy is in play in the way we've discussed, you're not suggesting those words apply in this case, are you?
Right. We need to take it in context, the whole of that sentence, or can demonstrate no adverse impact on the integrity of a nature conservation.
Yeah. So in terms of that wording and the way I've described to you, you're not suggesting that that is in play in this case, are you? Or are you?
if that fell within that designation, and it was the appellant that did it, then yes, that would apply. But if it's nothing to do with the appellant, it's nothing to do with the appellant.
Okay.
Taking the wrong baseline.
And in respect of, while we're on this part of the proof of evidence, in respect of the blue infrastructure policy NE2, we can see there the bold words that buffer zones to all water courses of 8 metres for main rivers and 5 metres for ordinary water courses. Clearly, that part of the policy isn't complied with at the moment because the water course has been removed, hasn't it?
Indeed, yes.
Yeah. And what I understand you to be suggesting is that in respect of sites A and B, which is the sites you're instructed on, that the water course could be reinstated. That's right.
Yes, indeed, yes, and
With the
that's
5
what
metre
should
depth.
happen.
Yeah. So you're suggesting a condition.
I feel quite passionate about that, to be honest.
All right.
I think it's quite important.
That's helpful. Okay. So can we then move on to the next topic, which is the thorny topic of great crested newts. And really it's just to nail down some specifics in terms of great crested newts and what has and hasn't been surveyed. So can I ask you just to have a look at, again, one of the documents that we've already looked at, which is that in 2A.8. So it's the A series of documents, and it's 0.8. It is indeed, Inspector, yeah.
Okay.
And when you have that document on the first page of that Darwin Ecology document, you'll see 4 paragraphs down, it's talking about 2 ponds. And I just want to get your agreement, if I can, or to see whether you will agree with me that in terms of the 2 ponds that it describes there, pond P1 and D1, and you'll recall we looked at those ponds when Mr. Sibbett gave evidence. It's right, isn't it, that those ponds are the ones immediately to the east and west adjoining the site? Yeah.
I believe that's correct, yeah.
So Mr. Sibbett's correct, isn't he, that when one's talking about the pond which is identified within page 17 of the Architect report, the one that is said to be 110 metres to the southwest, that hasn't been surveyed for great crested newts, has it?
No, I think the point is that it's the ponds within the area, and the likelihood of great crested newts being in a different pond and not in those ponds is pretty remote.
So do you maintain that?
Even though, sorry,
No, go
even
on.
though it says in the Darwin report there that both the water bodies were assessed to hold good suitability to support email popping up. Go away. On the it's paragraph 1, 2, 3, 4 of the Darwin letter, and the last sentence says both of these water bodies were assessed to hold good suitability to support breeding populations of great crested newts, but they weren't there.
They weren't there.
No.
And if you have a look, just go back a document to the CD 2A.6 document, the Architect report. And again, if we look at the page we were looking at before, page 17.
Yes.
So you said that it's unlikely that they're going to be at other remote ponds. But if you look at the way the Architect report deals with it in page 17, to start with, it identifies the pond that it actually identifies in the 3rd paragraph is the one that hasn't been surveyed, because it talks about the one within 500 metres of the site. So in terms of the way that the ecologist who's drafted this report is concerned, clearly 500 metres is a significant milestone, because below 500 metres, the pond is clearly one which they feel ought to be surveyed, isn't it? If one reads that paragraph.
Yes, I mean, 500 metres is seen to be the maximum extent. Some ecologists say 250 metres.
And whichever of those measurements one takes, plainly the pond 110 metres to the southwest is within either, whether it's 250 or 500, isn't it?
110 metres, yeah.
Yeah. And so if we turn forward and we look at page 21 of the report, where we're looking at amphibians. 21, Inspector. Where the ecologist from Arbtech is talking about doing an assessment of the pond within the third column recommendations, plainly that recommendation hasn't been heeded, has it? Because there hasn't been a assessment of that pond, the pond that they identified.
No, there hasn't been assessment of that pond. No, quite correct. That's what it says, matter of fact.
And in terms of, can I ask you to turn to the Peter Willow's decision of Burnt Hill, which is at CD A8. Oh, that would be helpful. Thank you. It is. It's CD 8.4, Appendix 16. Yeah. And it's just that paragraph we looked at before, Inspector. So when you've got Mr. Cottle's copy that is helpfully handed up, you'll see it's page 13 again and paragraph 64.
Okay.
So we see there that that paragraph starts advice on when survey information should be sought, and the third line down saying that this indicates that a survey should be requested when there is a suitable water body such as a pond or ditch within up to 500 metres. So again, that corresponds with the Arbtech measurements, doesn't it, that they give on page 17 and 21?
Yes, I think the reason being that it could be less than 500 metres is depending on the terrain, if you've got a main road in between, that sort of thing.
So clearly, if one reads on in that report, we see that this suggests 5 lines down that a survey would be appropriate in this case. And we go on to see at the bottom, the bit that Mr. Sibbett read out, that great crested newts can colonise ponds quickly, and certainly within approximately 4 years that this pond has existed. So Mr. Sibbett was right, wasn't he, to have concerns that the pond which Arbtech had asked to be surveyed hadn't been surveyed, and that within a 4-year time period, newts might move from that pond to the ponds which are adjacent to the appeal site. That's a relevant consideration, isn't it?
It's a relevant consideration, but what would have happened in that time frame is that the site had been occupied. So it's occurred. I don't see how that would make a difference related to that.
I just want to ask you, conscious of the time, I just want to ask you some questions about wood white butterflies. So if we can move on to that topic next, please, Inspector. And in that regard, I just want you to start, and it's within, I'm going to ask you to look, Mr. Woods, within Mr. Sibbett's appendices. So you're going to need to look at CD 8A.3. Yeah, that's right. Now, these, Inspector, you'll recall, are actually bound in together. So as my learned friend, Mr. Cottle, pointed out, one's got a long number of pages in this document, unfortunately. So Mr. Woods, if you're looking at it online,
Okay,
it's going to be a little while to get there. Yeah, so I'm going to turn it up online as well. We need to get to Appendix 10 and page 4 of Appendix 10. So that's where we're headed.
have you any idea what internal page it might be, please?
I think it's going to be about 2/3 of the way through, but when I've got it turned up, I'll help as well. Right. Okay. So it's document number CD 8A.3. Yeah. And within that, it's Appendix 10. And I'm going to give you the PDF page number as soon as I get to that.
What are you looking for?
I'm looking for Appendix 10, which is the
I'm down to 14 now.
it's the Mr. So it's Mr. Herman's representation that we're looking for.
You think it's 227?
225 is commissioned by Major.
Oh, 223?
2.
Headed up, the first line is the wood white is a delicate, slow flying butterfly.
So I think we've got, so it's it starts Appendix 10 at 225.
Letter of the 15th of October 2021, is it? It's page
That's the one. Yeah. So,
226.
so page 1 is 226, and then we've got 227, 228. So it's page number 229.
229.
229, yeah. It is, yeah.
That's my reference to the dates, incidentally, which is the neighbour saying over the period 29th to 31st of May 2021. That's the date that I had in mind.
And so in respect of, you can see there's endangered species wood white butterfly, Mr. Woods, which is about 2/3 down that page. And that's the wording that I want to just take you
Okay.
to, where it says that Thatched House Farms land adjacent to the site is host to the endangered wood white butterfly, one of the UK's rarest and most threatened species. It's reasonable to assume that the proposed site would also have provided such habitat prior to the depositing of hardcore. So in respect of the wood white butterfly, we've got that statement of Mr. Herman, who, as I understand it, is the owner of Thatched House Farms land, saying that his land is host to that butterfly, and he thinks that given its flight patterns, it would have been reasonable to assume that the proposed site would have also provided such habitat prior to depositing of hardcore. That's correct, isn't it?
Well, that's what he's saying. But you could say equally that if he's in that area where the endangered wood white butterfly resides, that the erection of tin sheds on his land might have had some impact on it.
And
on the actual land where it's designated, rather than the appeal site, which is not on the land that's designated. So it's one rule for one rule for another.
And in terms of the significance of the butterfly itself, if you can just turn forward, and again, it's going to be in the same document, so I'm going to need to find a page, but it's going to Appendix 12, and it should be, it's quite close to the back of the document. And it's got an internal page number 57 at the bottom. So it is on page number 269.
Okay. Okay,
So this is part of a document which is the guidance for selection of sites of nature conservation importance, which are called SNCIs in Surrey. And we can see there that there's a table which lists butterfly species of importance, and it has criteria above the table which introduce it. And little b there says that sites supporting a butterfly species within list A in table 7. And if we look in table 7, list A, we can see that the wood white appears there about five butterflies down, doesn't it?
it features along with a large number of others.
Yeah. And in terms of the way in which the relevance is described at the bottom of that page under justification, it tells us that the presence of a breeding population of a butterfly species from list A would indicate a good quality of habitat worthy of SNCI selection. So just pausing there, the presence of that butterfly clearly is something which indicates good quality habitat by virtue of it being included within table A, isn't it?
Yes, not on the appeal site though.
Not on Thatched Farm either.
Well, Mr. Cottle, I mean, you know better than to
Well, no,
than
but
to just keep answering
the-
questions. You've got to be quiet while I'm cross-examining and come back in re-examination.
But the document doesn't go as far as you say it does.
Well, all I'm doing is saying it's something which indicates significance. I'm not putting anything beyond that. So in terms of the next topic, I just want to ask you about the mitigation compensation issue, Inspector, and that's the last topic for cross-examination. And in respect of that, I just want to recap with you, Mr. Woods, where we are in terms of what surveys have been carried out as a matter of fact, just to see that we've got agreement of that for the inspector. And then I'm going to talk about the principle and whether and why that matters. So in terms of surveys being carried out, we've looked at the Great Crested Newt survey, and we've agreed, haven't we, that although a survey was carried out, it didn't survey that pond which was identified in the Arbtech report. That's fair, isn't it?
It didn't survey one of the ponds, yeah.
And in terms of badgers, I know you were listening carefully when Mr. Sibbett gave his evidence, and you'll recall that he explained there that the Arbtech survey required camera traps to be laid out. And you remember the inspector, Mr. Sibbett, talked about whether it's 3 to 5 or 3 to 4 weeks of camera traps that were needed. And Mr. Sibbett explained that what had been done didn't involve laying out those camera traps. So I don't think you dispute that, do you?
Well, there was badger walkover and there was no evidence of activity or badger sets identified within 30 metres of the sign.
Yeah, so that's, I mean, so you agree with me, but you say what was done instead was the walkover, but you accept there were no camera traps placed in there.
Well, no, I mean, that's so what you do first is if there was some evidence of badgers, droppings or badger hair, then you would investigate further to see if there were sets nearby or main sets or intermediary sets, and you do the necessary surveys with camera surveys. But if there's no evidence of badgers, then there's nothing to further survey.
So was it just a walkover?
Yes, that will be the starting point. You do the walkover, and if the report identifies, yes, we have a potential badger issue here, we need to find out whether it's whether they're foraging in that area or if there's a set nearby, and you do further investigation.
He did obviously go on his point as well. In my view, should be executed. That's not
So
The question's been answered.
Yeah.
No need.
And it's in the Darwin letter, the 16th of January. All right.
So I mean, the only point to put to you on that, I'm grateful for that answer, is that it wasn't Mr. Sibbett saying that there should be wildlife cameras over a period of 3 to 4 weeks. It's the Arbtech report on page 24 that recommends that within the badger section, isn't it?
If you did a further survey, that's what you do. But if there's no evidence of badgers, then you wouldn't do that. You wouldn't do a camera, cameras in areas normally where a badger set is to see whether it was an active badger set or not. You'd have the camera set up for 48 hours and see what it produces. But if there aren't any sets, then there's no purpose, no purpose and no evidence of badgers of doing a survey relating to badgers. It'd be like doing a survey for fish or something on a dry piece of land.
So I would suggest to you, although I don't really see the need to, but I would suggest to you the reason why you put camera traps is because badgers may not be visible when you're walking there, but camera traps are more likely to pick them up. What would you say to that?
No, I wouldn't accept
Disagree.
that.
All right.
We had a survey on a site recently, and it was a housing site, and there was a badger set not within 30 metres of the site. So the ecologist recommended that a hand clearance was undertaken of vegetation not closer than 30 metres to see if there was evidence of badgers. And there wasn't any evidence of badgers. So you do your walk over and you find out whether there's potential for badgers. And then at that point, you do a further survey.
And then in terms of the botanical evidence that Mr. Sibbett gave, it's right, isn't it, that although one has a habitat walkover, one doesn't have a document where somebody has done a botanical identification of the various shrubs and flora and fauna on the site.
I think these things are going to be proportionate, and that's what the PPG says. I mean, your line of questioning is leading me to think, well, actually, you shouldn't have any site developed for anything because it becomes impossible.
And in respect of the other elements that Mr. Sibbett discussed, the roosting, foraging bats, the hedgehogs, the birds, the invertebrates, well, clearly it's common ground that there's been no surveys undertaken in respect of any of those creatures.
No, there hasn't. But I'd be surprised if there weren't bats in the area where there are trees. And so therefore, you, as I said earlier, you do measures for bat enhancement by having bat boxes and a proper lighting strategy to make sure that the area above weren't floodlit and damaging their flying foraging area.
So in respect of the approach to not the removal of the habitat, but in respect of the approach to ascertaining the harm to endangered species or species of importance that might have been present on the site, Mr. Sibbett has provided an appeal decision at Appendix 5. And so if we scroll back in the document that we've got open,
Okay.
we should be able to find Appendix 5. Mr. Sibbett's appendices again, yeah.
Roughly what?
Well, I'm doing the exercise as fast as I can, so my little fingers are flying across the computer.
Is it the Old Berry Road?
I just want to try and find it first. Yes, that's the one, Inspector. Have you got a PDF page? Oh no, you've not got your link on, have you? Mr. Cottle's won the race this time.
Okay.
Brilliant. So when you're in there, you want to turn to PDF page 155, which is where we're dealing with ecology. And really, it's the point of principle in relation to this particular protected species element of the harm, where the inspector is dealing with ecology there in paragraph 21.
Yes.
And he says that it's a common ground that there's a strong probability of newts and possibly bats, both protected species, being present in the adjacent pond and building A. Guidance on the conservation of protected species is given in ODPM Circular 06/2005. At paragraph 99, the circular advises that the presence or otherwise of protected species and the extent to which they might be affected by the proposed development must be established before planning permission is granted. And he then goes on to explain that obviously that hadn't been done in that particular case. So you see what the Inspector Young has found in that case. whilst dismissing those appeals. You obviously urged the inspector to take a different course in this case.
I
but
do,
He's
like,
applied.
like the Buckinghamshire decision where the different course of action, where the pond for the newts, where there were newts, was immediately adjacent to the appeal site. If we were in the council chamber today, the pond would be in the council chamber where the park gallery is.
I mean, you'll recall that that case was debated with Mr. Sibbett earlier on, and I'm not going to take up much time on it, but it's right, isn't it, that Inspector MacDonald, when she was determining that case, in paragraph 2, made it clear that the works were not in accordance with the plans and details, and she based her assessment on the evidence submitted, not what was on site. So she removed the word retrospective from the description, didn't she? That's true, as a matter of fact.
Yes, because retrospective hadn't occurred.
But in terms of the approach that's been taken by Inspector Young in the decision I've referred you to, he's applied the correct guidance, hasn't he, in the circular? And the circular does say that development must be, that those matters must be established before planning permission is granted. So that's the approach the circular recommends, isn't it?
Well, surveys have been undertaken and we've been through that point.
So if the inspector were to take that approach, it wouldn't be appropriate for him to condition, because the work would need to be done before permission's granted, wouldn't it? That's the
The
point.
surveys have already been undertaken.
Yes.
It's different in that case. Surveys weren't there at all.
But the circular advises that the presence or otherwise of protected species and the extent to which they might be affected must be established. So is your evidence that you feel that the surveys that have been done are sufficient to do that, and so you disagree with Mr. Sibbett where he says that they're not? Is
Yes,
that a correct?
I do disagree with Mr. Sibbett. The surveys were undertaken, and we're suggesting by way of condition to do some enhancements that might encourage species onto the appeal sites.
And is your answer unaffected by the cross-examination that we've just had, where I've agreed with you the surveys that have actually been undertaken in respect of the great crested newts, the badgers, the walkover, and then pointed out that in respect of all of the other interest, including bats, which are protected species, there hasn't been any survey done in respect of. Does that not affect your answer as to whether or not what's been done is adequate?
Great crested newt surveys were done, so they weren't. All the ponds weren't surveyed, as you quite rightly pointed out, but the inference is that there was no presence in the ponds that they were surveyed. So why would there be on the other pond? Because the ponds that were surveyed were conducive to having a population of great crested newts. So put that to one side. Badgers, there was a walkover survey undertaken and no evidence of badgers. Bats, well, yes, there will inevitably be the possibility of bats in trees, as there are in every area where there are trees. And I'll repeat yet again, what you would do is in mitigation, you would have a lighting strategy that works and direct a light to the ground in the manner I've suggested, and B, in terms of enhancement for the bats, you place some bat boxes in the trees. It's a normal type of thing that you would do. You raise the points. Certain surveys have been undertaken, and regard to the bats, yes, there will be bats in trees, and that's the way you deal with it.
And so one final question, and that's this. So given that the framework at paragraph 193 says, refers to significant harm to biodiversity, and it says that if you've got significant harm resulting from a development and it can't be avoided, adequately mitigated, or as a last resort compensated for, then planning permission should be refused. Would you accept that if the inspector differs from you in terms of the degree of harm and forms the view that the harm is significant, then that would be a reason to refuse permission in the circumstances of these appeals?
There's no reason for refusal relating to biodiversity, and the the appeal sites are exempt from biodiversity net gain. However, what we're suggesting, for example, on site B, we showed with a landscaping plan how you can enhance matters so to improve biodiversity.
Yeah. So, I mean, if even in the face of your suggested improvements, if the inspector found that significant harm had been done by what's been done on these appeal sites, then that would be a reason, according to the framework, why permission should be refused, shouldn't it? You differ as to the degree.
Well, it needs to be balanced. You put that in the balance. If the inspector, let's assume the inspector found significant harm on the appeal sites that I'm dealing with, you then got to weigh the benefits, the public benefit of having a site rather than the occupants having a roadside existence, the personal circumstances of the appellants, which you'll come to tomorrow, and the fact that there is a lack of a 5-year supply of gypsy and traveller pictures in the borough. So inevitably there will be harm, and it may be that if there was to be significant harm, then it may be offset by all the positive points.
Inspector, I'll leave any other points for submissions. Given the time, I think I'll leave it there. Thank you very much. Thank you very much, Mr. Woods.
Thank you, Mr. Lentott. Mr. Woods, I did have a question or two, but they've been addressed, so I have nothing further to ask you. It was clear earlier on that Councillor Sullivan does have a question for you, but I see the parish council representatives have all gone, so I'm going to give her the opportunity to do that on Friday.
Okay.
Well, I'd like to come in after that, if I may, if I have an opportunity.
Of course, I'd always give you the opportunity to re-examine.
That's right, and just
Are you saying you want to defer your re-examination completely?
That's right.
Rather than doing it?
I do. I want to stop now. What I would like to say, just to invite you to read very carefully Inspector Young's decision at Appendix 5, which was for new residential development in the open countryside, conventional housing, and had to meet a threshold of exceptional circumstances. So we'd say there's a different balance of considerations for a traveller site.
Right. So
that would be a submission I'll make in closing.
Well, save it till then, Mr. Cottle. That's fine. That's Mr. Masters. Carry on, please.
You were asked just a moment ago about 193 and significant harm, which is 193A. And you rightly pointed out that reason for refusal wasn't about biodiversity, but can I just remind you that if the inspector finds there's no 5-year supply, we're in 11D, and the terminology there is significant and demonstrably outweigh the benefits. Do you think that any harm here significantly and demonstrably outweighs the benefit?
No, I do not.
No further questions.
Thanks, Mr. Masters.
I hope we're calling it a day at that point. So.
Well, yes, it's 5 o'clock, and with the exception of the parish council, we're up to date with the timetable.
So could we go back to 10 o'clock tomorrow rather than 9:30? Because
Well,
it's been a long day today, and I need to take some instructions in the morning before we start.
well, I think it's helpful to all parties to have the 10 o'clock start, because inevitably things crop up during the day to
Yep.
inquiry, and you need to review those. So my default would be 10 o'clock. Looking at the timetable for tomorrow, it's been modified since
It
it
has.
was
So we're-
prepared.
I think we're doing well. We're on top track.
Well, I think so. We have got the addition of Councillor Britton, who isn't on the timetable,
But we've got the loss
but
of,
we've got the loss of Mr. Rowe, and I'd put Mrs. Doherty on as well.
which is,
And also helpfully, Mr. Lintott's reduced the likely length of his questionings. So my inclination is to agree with you, Mr. Masters, and go for 10, but I'll just hear, I don't know if the other advocates want to be
I
cautious.
don't have a problem with that, given what I said earlier on. I think we're on track. So if it would help Alan, I'm content, Inspector.
Mr Cottle, are you content with that as well?
I'm very content to start at 10 o'clock, but I think we'll go shorter than you think tomorrow. And Mr Ward ought to be prepared to give his evidence in chief. And I've spoken to Mr Wood about that. It wouldn't be cross-examination in his absence. That'd be very important to have Mr Wood there. But I think that we may need to think about Mr Ward tomorrow afternoon.
I don't think we'll go that short, so that's my view.
Well,
But I
maybe,
mean,
well, okay, it's just being ready in case we are.
Yes.
I mean,
Winter.
I had assumed, Inspector, that if we got to the stage in the programme where it was time for Mr Ward to give his evidence, that he would just give it. So, I mean, he will be ready, willing and able to give his evidence if required. But if we
Yes.
don't get, if Mr Cottle's enthusiasm isn't matched by Mr Masters and we don't quite get there, then, you know, so be it. It'll be back on schedule.
Yeah, but you've no objection to that if we
No,
get there?
absolutely not.
No.
but can we keep things here again tonight? In this
I
room?
think we can because
Yes,
John
yes,
said, yeah.
I'll actually, just an update on that. We're certainly fine for the week. Over the weekend, we won't be able to because we've got a committee meeting here on Monday. But
right.
we can arrange for
Can I, if I put
Your
things in my
stuff to
boxes,
be
can they be stored?
they can be stored somewhere here.
That'd
yeah,
be very helpful. rather
over the
than-
weekend, yeah.
Thank you very much for that. Anything else before we rise for the day? Nothing,
Not
Mr
from me,
Lintott?
no.
Mr Cottle? Okay, thank you all very much. The inquiry is adjourned and we resume at 10 o'clock tomorrow morning.
Yeah, sure. I'm just looking for something. Give me a minute.